Deliberative order, item number 1.
For reasons mentioned in the judgment, this revision petition is allowed. And the impugn order dated 29/1/2026 is set aside. The matter is again remanded back to the tribunal for affording opportunity to both the parties to lead evidence in support of their respective claims in pursuant to the provisions contained in Rule 13 of the Assam State Maintenance and Welfare of the Parents and Senior Citizens Rules 2012, and thereafter pass such order as it deems fit as expeditiously as possible.
Obliged, let's.
Matters. Worship with the question on the other side, Lordship. I make them number 31, Your Lordship. I have some difficulty to read, Your Lordship.
31.
After 2 weeks, Your Lordship.
Heard Mr.
He go over, Your Lordship.
T. Gogoi, learned counsel for the respondent, who prays for an adjournment. He submits that he has informed learned counsel for the appellant regarding his prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
May it please your lordship. Your lordship, with due consent from other side, I beg to mention item number 12 of today's list, your lordship. We are for the respondent in this case, your lordship. Conducting counsel, Mr. R. Goswami, has some personal difficulty, your lordship. So, your lordship, I pray that this matter may be taken up after 3 weeks, your lordship.
Heard Ms. P. Bothakur, learned counsel for respondent number 5, who prays for an adjournment. She submits that she has informed learned counsel for the appellant regarding her prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed after 3 weeks on a date to be fixed by registry.
Similar prayer is for item number 23 to 29 of the supplementary list, your lordship. In this case, we are for the appellant, your lordship.
You have informed the other side.
Lordship, we have informed.
Same order, 23 to 28.
Obliged.
Lordship, it's a very old matter, Lordship. Kindly a date may be fixed.
Which one?
With 23 to 29.
After 3 weeks.
After 3 weeks.
Any date.
Mr. Goswami is ill.
Lordship, his son has expired yesterday only.
Okay. After 3 weeks.
May I please, your lordship, I would like to mention for item 3. Kindly fix this matter on 2.
Why?
Because my senior sir is on the way. He is in train and train is late. Running late, my lord.
Okay. Item 3 we'll take it up at 2. Today at 2.
Obliged, my lord.
Your Lordship. Lordship, I beg to mention item number 10 and 11, Your Lordship. And for the respondent, we seek adjournment on the ground.
On what ground?
Your Honor, the engaged counsel H. Moria, his daughter is suffering from chicken pox, Your Lordship.
Okay.
That is why he cannot conduct the hearing.
What is your name?
My name is Nirmal Sahu.
Heard Mr. Nirmal. Item number 10 and 11.
11.
Heard Mr. N. Sahu, learned counsel, appearing for Mr.
H. Moria.
H. Moria, learned counsel for the respondent, who prays for an adjournment on the ground of medical urgency. You are for the
Appellant, Your Lordship.
learned counsel for the appellant does not raise any objection. Hence, the prayer is allowed. Let this matter be listed.
Date may be given of 2nd of September, Your Lordship.
6th October.
6th October.
6th October.
Much obliged, your lordship.
Ladies, can you show? I approve.
May please also my senior P. Bhattacharya election for number 5, standing for this.
What is the matter?
Item number.
2, Your Lordship. It is a matrimonial appeal, Your Lordship.
It is not yet admitted.
Not admitted, Your Lordship.
We'll admit it and fix it for
We are
hearing.
playing for stay also, Your Lordship, for that.
What stay?
Stay of the impugn effect of that order, Your Lordship.
What is the order?
Order is at page number 28, Your Lordship.
What order you are impugning?
That order, Your Lordship. 17/8/2024, page number 28, Your Lordship.
What is that order? What it says?
Your Lordship, a token of 30 lakhs rupees of maintenance has been allowed in favor of the respondent, Your Lordship.
Your husband?
I am husband, Your Lordship. Yeah, without considering assets and affidavit of assets and liabilities, Your Lordship. That is the strong.
Divorce has been granted.
Granted, Your- That is, there is no Lordship. I don't have any objection regarding that, Your Lordship. I have only preferred this application against the amount of maintenance, Your Lordship. That is 30 lakhs rupees. It is very excessive, Your Lordship.
Yeah.
And without considering the assets and liabilities, Your Lordship.
Senior is.
Okay, let him come. Let him.
Obliged.
Order, item 4.
Yeah, please, Your Lordship. Lordship, in this matter, I am appealing for the respondent number 1, 2, and 3. We have given the, for filing the objection against the delay condemnation yesterday, Lordship. The same is not on record.
You have filed, already filed?
Yes, yesterday we have given.
Okay. Heard, what is your name?
A not Lord.
Heard Mr. Enath, learned counsel for the applicant. Also heard Mr. D. Chaudhary, learned counsel for respondent number 1, 2, and 3, who submits that the said respondents have filed their written objection against the prayer for condemnation of delay. However, same is not tagged with the record. Stop. Registry is directed to tag the written objection filed by the respondent with the record and list the same again on 31st July.
Item 5.
Service may be awaited. Newspaper respondent 2 and 3.
Heard Mr. K.K. Bhatto, learned counsel for the appellant. Also heard Mr. M. Talukdar, appearing for
Respondent number 1.
respondent number 1. On perusal of the office note, it appears that office note dated 26/6/2026, it appears that service report in respect of notices issued to respondent number 2 and 3 are awaited. Stop. The registry is directed to place the postal track consignment report of notice issued to respondent number 2 and 3 before this court on the next date fixed. Let this matter be listed again on 7th of August.
Item 6.
Right, please, Your Lordship. Well,
Yeah.
AD report is awaited.
What is your name?
R. Ghosh.
Heard Mr. R. Ghosh, learned counsel for the appellant. On perusal of the office note dated 6/7/2026, it appears that service report in respect of notices issued to respondents by speed post is awaited. Stop. Registry is directed to place the postal track consignment report of the notices sent through speed post to all the respondents before this court on the next date fixed. Let this matter be listed 10th of August.
I'm obliged.
Item 7.
May I please, Your Lordship? An IA for delay condemnation has been filed before in connection with the MSC.
Notices have been served.
No, my lord.
You are appearing for?
1, 2, and 3.
How many respondents are there? Three. For three,
3 is the daughter.
daughter. And 4 and 5,
4 is the owner cum driver and 5 is the mother of the deceased. She was being made and respondent in the main claim case at the trial court.
but have you taken steps for issuance of notice?
My lord,
No,
the matter has been fixed.
come up for the second time. For the first time, heard Mr. C. Fukon, learned counsel for the applicant, also heard Ms. S.R. Das appearing for respondent number 1 and 2. This application under Section 5 of the Limitation Act has been filed by the applicant / National Insurance Company Limited, praying for condonation of delay of 690 days in preferring the connected appeal. Issue notice to the respondents. Since Ms. Das has appeared for respondent number 1 and 2, no, you have received the copies?
Yes.
No formal notice need to be issued to the said respondent. However, learned counsel for the appellant is requested to furnish copies of memo of appeal along with annexures to the learned counsel for respondent number 1 and 2. As regards other respondents, the applicant shall take steps for issuance of notice on the said to them by speed post as well as by usual mode within 7 days from the date of this order, returnable on 19th of August.
My lord, the other side, the respondent filed a succession case for, my lord, some amount of cash pending in the bank of the deceased, my lord. Who is the, my lord, from the side of the, my lord, the property is the self-acquired property of the female, my lord. And the person who filed a succession case is from the side of the female deceased, my lord, my lord, nephew. Deceased brother's, my lord, son.
Deceased
Brother's son.
brother's sons. Which class of heir he is?
Admittedly, my lord, he has a better class than me.
Then why have you filed this appeal?
I must admit, my lord.
Then we'll dismiss this appeal.
On merit, your lordship may decide.
Well, if I may be, he's been so fair. It is since 2017, I've been trying to bring this subtle issue that when in intestate succession, Hindu female, the given class of heirs. So once you locate that, and if it's a gentleman around who comes in the first class, then you have to go to the men. Then I come, he accepts it, and I know I can just prove it on record. That's what move. It's apparently wrong. Express it.
As per 15 of the Hindu Succession Act, it comes firstly upon the sons and daughters, then secondly upon the heirs of the husband,
These
thirdly upon the mother and father.
materials are there on record.
Yes, yes.
Okay, okay.
So far as our case is concerned, it is by the law. They are trying to make out a case against the law.
Okay, I'll dispose it of today.
Lordship,
I'll dictate the order in chamber.
my lordship. The lordship would excuse me if I may say, this afternoon I'm leaving for Puri for Rath Yatra. I may not be there. If anything required, my colleague will be there.
Your plea is that the appeal should be dismissed.
Appeal should be dismissed because female intestate succession, we are the lady who's died is my father's elder brother's wife.
Father's elder brother's wife.
Now we squarely come within the interpretation. If lordship, if I may elaborate, I can do it from the record, the law. They know it. We come, then their plea is nowhere with the law. If my lord would
No,
have,
let me, show me
yes, perhaps. My lord would have the Hindu succession.
Hindu
Act.
succession act. Section
15,
not Indian,
Hindu succession.
Hindu succession. Hindu law.
No, no. No, no, no. Easy. 15 minutes.
Yes. Yes.
May I read, Milo?
Yes.
15. General rules of succession in case of female Hindus.
Who are you? You are.
Me and my mother are before your lordships.
Huh.
My father's elder brother's wife is the person who has died. In Assamese, my Borma.
Elder brother's wife.
My father and my elder brother and his elder brother are no longer alive. Correct.
So you are heir of the husband of the deceased.
Lodge.
15.
I'll read it. Number 15.
15B.
The property.
No, what is your case? 15B or C?
May I just read that?
Yes, yes.
15.1. The property of a female Hindu dying intestate shall devolve according to the rules set out in section 16. A. Firstly, upon the sons and daughters, including children of any predeceased son or daughter and the husband. Here, it comes the husband. May I read on, Mino?
Yes.
B. Secondly, upon the heirs of the husband. No, husband is no longer there.
So you are heirs of the husband.
Heirs of the husband. Heirs of the husband. Thirdly, upon mother, father, no longer required. Fourthly, upon heirs of the father, not required. Lastly, upon heirs of the mother, no longer required. 2. 15.2. Notwithstanding anything contained in subsection 1, A, any property inherited by a female, we are not even required to go into that. It is not inheritance. 2B, any property inherited. So 2A and 2B are not even required. That is inheritance.
Okay.
Now, if I come to 15B, secondly, upon heirs of husband, then I would invite my lord's attention to section 8.
Males.
Males.
Yes.
Section 8. May I read?
In males,
male.
what kind of heir you are?
I'll read it. The property
Yes.
of a male Hindu dying intestate shall devolve according to the provisions of this chapter. A. Firstly, upon the heirs being the relatives specified in class 1 of the schedule. I invite my lord's attention to the schedule. Class 1, we do not fall.
Okay.
Class 1 in substance, my lord, is the person, the male person, his mother, his wife, his son and daughter, existing or deceased, and their sons and daughters. My lord.
Yes.
If I may just point out, my lord, under the Hindu Succession Act, only the son-in-law never gets anything. The daughter-in-law would always get. Now, 8B. Secondly, if there is no heir of class 1, then upon the heirs being the relatives specified in class 2 of the schedule, we will come to B of class 2.
Class 2, which category?
Of the schedule.
No, in class 2, there are 9 categories.
His father, gone. 2, sons, daughters, these are not required. 3, daughter's son, daughter's son's daughter, not required. 4, brother's son. Brother's son. Brother's son.
You are brothers.
Brother's son.
Yes.
I hit that 4, brother's son. 5 not required.
4-1.
6, 4-1 and 6 and my lordships. Six.
Brother's widow.
Brother's widow, that's all.
4-1 and
That's all. That's how the succession moves.
4-1 and 6.
If Lordship, if I'm able to rephrase my submissions,
Yes.
when we are dealing with intestate succession of a female, we come down to the point where we are located in the XY axis. Then if it proves for a male, we come to section A, take out the schedule 1 and 2. If it's 1, it either has to be the mother or the widow, wife, or son and daughter living or dead, except son-in-law. Son-in-law is never protected under the Hindu Succession Act. If it is not there, we come to the class 2. Class 2, each one takes against the other. So therefore we come there. That's my case.
And what is your case, Mr. Vishnu? You don't have a case.
They have a case. They accepted it.
You are
He is the lady's
My
brothers.
my pehi, matlab,
Pehi.
in
That's all.
a sanus.
so which class of air you are? 15.
Not there.
In the class 2, my lord, this father, son's daughter,
No,
brother, son.
are you a heir?
15.
You are also an heir.
I am also an heir from the side of the deceased
No,
paternal.
point
side.
out which under what to
15C would come.
15C.
15C, thirdly upon the mother or the father. So we are in B, 15B.
And you
From there, section 8 would come and he would
no,
come.
your case is clear.
15B.
Your case is clear.
15B.
But what kind of heir the appellant is?
My lord, I come under section 15C, my lord, any property inherited by a female Hindu from
Not
her
inheritance.
predeceased son,
Not inheritance.
self-equal
No,
property.
15C.
Self-employed property.
No,
It's not
15C will not. You are not father or mother.
No,
I am not the father and the mother.
You are also a nephew.
nephew.
I am also a nephew from the paternal side.
On the mother's side. I mean father's side.
Hmm.
Correct.
You are nephew from the
But my pehi died.
The ladies,
your
Father's-
brother's sister died.
yes.
No.
Your brother's sister,
My-
your father's
My
sister,
father's sister died.
father's sister.
But what is more important, section 16,
So you come in D, heirs of father. No.
Yes. D. Correct. D.
Yes,
D.
Mr. Bishwas, you have to tell.
Well,
In
15,
B,
D.
15D.
D. D. D.
15 small d.
15(1)D. Totally upon the heirs of the father.
Okay, therefore you will not get. Heard Mr. S. Bishwas, learned counsel for the appellant. Also heard Mr. S. L. Banik,
S. Body.
S. Banik, learned senior counsel assisted by Miss F. Begum. Dictation Bidruddin. The appeal is dismissed.
I'm grateful, Lordship. Obliged. Interim order to be vacated.
Everything goes.
Lordship. Grateful. In fact, my client has come down from Kolkata all the way, sitting behind me. Just for all these years.
I'll give detail order today
Okay.
itself in chambers.
My Lordship. Grateful. Obliged.
Please, Your Lordship. Impugn, judgment is page number.
Yes, we'll admit the appeal, Miss Bhattacharya. We'll admit the appeal. Fix it for hearing. There,
Because I have, no amount has been received, Lordship.
what is your grievance?
Grievance is not a strong first grievance.
Before, Lordship, that's me.
Grievance
Alimony.
is a permanent alimony, Your Lordship, 30 lakh rupees, Your Lordship.
You don't want to give anything or you want to give a lesser amount?
To give something, Your Lordship.
How much you want to give?
That much I have to take instruction, Your Lordship.
No, that you give in interim. We will grant stay subject to payment of some amount.
Otherwise, Your Lordship, this case has.
Because we don't know when hearing will take place. Once we
Yes,
grant stay,
Lordship.
the case may vanish from
Otherwise,
the causeless.
Lordship.
So
Otherwise,
you give something. How much will you give?
we take instruction from
Take instruction.
Lordship.
How much has been directed?
30 lakhs, Your Lordship.
You give 15 lakhs? Or
The fact, as per Burma and Ponacheti judgment, I think it should be 40%, Lordship, addition to the future prospect.
why? He's
He is a businessman,
business
Lordship.
self-employed.
Yes. 50% addition is in the higher side, it should be 40%, Lordship. That is the decision of the Ponacheti judgment, Lordship. And in this case, that will be applicable.
You
In
have a copy of that Pranay
Ponacheti judgment, Lordship.
Which Farah?
59,
You take back this after this judgment.
yes, Lordship. 59, Lordship. The later portion, just before paragraph 60 starts. Paragraph 59, last portion.
Yes.
Taking into consideration the cumulative factors, namely the passage of time, changing society, escalation of price, the change in price index, the human attitude to follow a particular pattern of life, etc., and addition of 40% of the established income of the deceased towards future prospect, and where the deceased was below 40 years, addition will be 25%, whereas the deceased was in between 40 to 50%. And paragraph 61, Roman 4. Paragraph 61, Roman 4. Lordship, got that, Lordship?
Yes.
In case the disease, in case the disease was self-employed or on a fixed salary, an addition of 40% of the established income should be the warrant where the disease was below the age of 40 years. This is relevant in this case, Lordship.
What was the age of the deceased in this case?
34, Lordship.
And where is the law which says that 50% should be the?
That was, Lordship, earlier on. Santosh Devi or Reshma Kumari, Rajesh, etc. Lordship. Now this Lordship constitutional bench judgment is followed also. Ponacheti judgment.
No, 3 says that if he has permanent job, addition should be of 50%. Pranay itself says.
Yes, but in this case, he was not in a permanent job. He was self-employed.
Okay. What else is your submission?
The rest, Lordship, regarding interest on the amount given to the future prospect, our stand is that Lordship, future prospect should not, future prospect amount should not carry any interest, Lordship.
Yes. Whether interest has been.
Yes, on the entire amount, it is imposed, Lordship. As per Honorable High Court judgment, Lordship, no interest is payable on the amount awarded in the head of lot of future prospect, Lordship.
Where is that then?
This is paragraph 21. Paragraph 20 on logical thought.
Yes.
Another ground of challenge to the impugned judgment is that the learned tribunal had awarded interest on future prospects, which could not be done in the case of Khushbu Scenaria versus Khanta Scenaria, Sirania versus Kamal Kumar Sobhari such and such, reported in
Okay.
such and such, and in
Okay,
case-
okay.
Yes.
Anything else?
These are the main grounds. And they have filed lordship one cross objection.
Cross
I
objection.
will give reply after yes.
For enhancement?
Yes.
Okay, yes, Mr. Jain. Yes,
Your lordship. Means it's
cross objections.
beside, so far, first round, they have already given up that age of the deceased is to be taken, not the parents. That point he has considered. And so far, in this case, just for introduction, lordship, an award of 7,50,000 were made.
Yes.
And so far the income is concerned, it was 7,20,000. Trial court took the income of the loss of income, that this is 5,000. Though claimant gave evidence that it is 12,000, but court take 5,000. And so far funeral expenses, it's all right. Loss of estate and this loss of consortium, these things are not there. So those are my part of my cross appeal. Here, lordship, this was of below 35 years, 34 years, 2 months, 15 days.
Whether he was married?
No, he was unmarried.
Unmarried.
He was unmarried. And he was a businessman even.
Okay.
And he was a businessman. They had a stationery shop and one broiler farm, your lordship. And for that, I have given some documentary evidence also. So for income, my claim was that it is 12,000. I filed a certificate from Gauhati, executed, and certificate issued by Secretary Malkma Traders Association that I was having a shop. That they have certified. Now, he was unmarried. And the tribunal, so far multiplier is concerned, it is all right. It's 16, it was taken.
Okay.
Income was taken 5,000. Multiplier 16, which he is not disputing. Deduction was 50%. So he says, as per this partnership, his judgment should be 40%. That I also consider. That position is very clear after the this Panasati case. Now, your lordship, regarding income, he has come. That income is taken is too high. Now, in this regard, my reply will be, your lordship. The assessment of income was 5,000. He was having occupation, business, and income 12,000. And in this regard, the mother of the deceased, he gave evidence of 2 persons, beside herself. Herself, because she said that my son, he used to earn rupees 12,000, this much. And one Surendranath Deka, I mean, this is father, and PW, I'm just coming over to evidence of PW2, your lordship. He is Bhupen Chandra Kalita. He is a eyewitness and also a retired school teacher, your lordship. And in his evidence, he stated that he was having a broiler farm, which was closed after his death, 6 months back, after 6 months of his death. So far, the this stationary farm is concerned, mother says it is now looked after by his son. He was also one of the sons. Other 3 sons are there, and their son now looking after the stationery shop. And so far, the stationery shop is concerned, your lordship. I'm just coming to evidence of PW1. Lordship, the PW1 is mother, your lordship.
Yes.
And she exhibited, apart from her oral evidence, she exhibited, your lordship, one more thing, your lordship, this is was a bachelor, BA degree holder, your lordship. And this, that regard, her statement is there. She produced exhibit 6 is the high school living certificate. Exhibit 7, your lordship, PW1. She was BA pass certificate from the college. Now, your lordship, so far as income is concerned, 2 documents. One is exhibit 8, and next is exhibit 9 and 10. These are regarding income, your lordship.
What are these?
9, 8 is your certificate issued by Gauhati that to prove that he was having business, having a shop and a broiler farm. That was Gauhati, he has given evidence.
But what was the income? He has not stated.
Income, I'm coming. Income, mother said, in regarding income, they are not saying, but he was doing some business that they are proving. I'm coming to this W1.
So the tribunal held that though you have established that he was doing some business, but you failed to show any
Because documentary
proof.
evidence was not. But
Therefore, it was held.
PW2, he's a school retired school teacher, you will say. He gave evidence that he was having these 2 business, and his source of our broiler farm is concerned, it was closed after 6 months of his death.
But what was the income from the
Income, income, mother said he used to earn 12,000 rupees. So far income is concerned, I will submit, your lordship. It is not necessary that documentary evidence for this small business, those are not necessary, because I will come to some judgment, your lordship.
No. Before going to judgment, on facts, the tribunal held that though you are able to prove that he was engaged in some business, but no concrete evidence of his income.
Concreteness, no written evidence was there. Documentary evidence.
Therefore, tribunal took it at rupees 5,000.
Yes. Lordship, so far that.
In your cross objection, you are what you are claiming that?
Regarding, I am claiming that my income, which was taken by tribunal 5,000 rupees, ought to be more.
How much? How much?
It should be at least, your lordship, because mother says 12, and from his 2 business, because even if so far the stationery farm is concerned, his brothers are looking after, but a person of 35 years, if he is doing that, doesn't mean that he was not augmenting the income of the deceased and income of the family. After his death, there must be loss of income, your lordship. Mother says 12,000. It may be lesser than that. But
how much?
Let's see, I submit that it should be at least, your lordship, 8,000 rupees.
How this court will assess that it should? It should not.
Judgment, lordship, in this regard regarding the documentary proof of evidence.
No, the tribunal has assessed your income at 5,000. You have to show in this cross objection that tribunal was wrong for this reason or that reason.
That so far the stationery farm is concerned. Though now after his brothers are looking after that business, as mother has also admitted in the cross examination. But you know, see, he was a 35 years man. He must have contributed, augmented the income of the family, because it's a joint family, you know, see. Because in joint family, you know, see, when business is there, any one person, what he's earning, that is difficult. So mother says it is 12,000. And you know, say 5,000, you know, it is minimum income nowadays, taken 3,000, 4,000 rupees, you know, see. Even minimum wages is that, you know, see. And you know, see, even very small, this vegetable shopkeeper and all this court has held very 7,000, 8,000 like that. Supreme Court has held your this judgment I will give your lordship in this regard. And it is PW2 says that the business was closed. So far this farm is concerned, that business was closed. Broiler farm was closed after his death. In this regard, your lordship, if your lordship permit me, I like to cite 2-3 decisions, your lordship. Your Lordship, first judgment I am citing, Your Lordship, 2013 16 SCC 719. That is page 1 of my this written submission, Your Lordship.
Yes.
Your Lordship, he was a policer. He was a policer. Your Lordship, in paragraph 4, Your Lordship, file, his age was 25. He was policer. It is in paragraph 4, Your Lordship. And this court, Your Lordship, may come to paragraph 4 and 7 of this judgment, Your Lordship. Lordship, may I read paragraph 14?
Yes.
It is urged by the learned counsel for the appellant. Lordship, it is serial page number 4, Your Lordship.
Yes.
Serial page number 4.
Yes.
It is urged by the learned counsel for the appellant, Mrs. Saroj Rechura, that the Gujarat High Court, in exercise of its appellate jurisdiction, has modified the judgment and award passed by the tribunal after a long lapse of 11-12 years, which is in violation of the right of life and natural justice and statutory right of the appellant under the provision of the MB Act. Another ground is that the High Court was not right in holding that the compensation awarded by the learned member of the tribunal is excessive, and consequently the direction issued to the appellant to refund an amount of rupees 99,500 along with interest of 9% interest after long lapse of 11 years is wholly unjustifiable in law. It is submitted that at the time of death, the deceased was aged 25 years and was hale and healthy and would have lived long had he not met with the accident. Prior to the accident, he was engaged in the work of polishing and coloring and was earning 4,000 to 5,000 rupees. And the tribunal, this, Your Lordship, it was held that amount it was held, Your Lordship, in this judgment. It is in paragraph 7, perhaps. Yes, Lordship, may come to paragraph 7. Tribunal has taken up a sum of 15,000 per annum as provided in the second schedule to section 163 because there was no documentary evidence. So table was taken. F, as a notional income on the basis of the ratio laid down in Gujarat High Court in so and so. It is held that the datum figure is required to be taken into consideration for compensation in fatal cases. The same was applied to the case on hand by the tribunal, and further rupees 30,000 was added to the figure, which was then divided by two such that net yearly income comes to rupees 22,500, out of which 1/3 amount was deducted towards personal expenses and maintenance of the deceased, and thus the net awardable dependency was calculated to rupees 15,000 per annum.
Now, why are you relying this judgment?
Lordship, it was held.
How it helps you?
It was held rupees 5,000 for this person. It was 1,500 held by the tribunal, and High Court, Supreme Court held it 5,000 rupees. Lordship.
So in this case, tribunal has already held your.
I was doing business, Lordship. And I'm a learned person. I am a degree holder.
No, but how this judgment helps you?
Because he was a policer. And his income was taken as 5,000 rupees. That is my submission, Your Lordship. I was in better footing than this person, Your Lordship.
Okay.
Then, Your Lordship, next judgment I am giving, Your Lordship, 2011 13 SCC 236. It is at page 11, Lordship.
Yes.
Lordship, he was a coolie. And he was a coolie in para 13, Lordship, I kindly see. Para 2, the fact of the present case are the follows. The appellant was working as a coolie and earning rupees 4,500 per month. He was riding a pillar and he died, Your Lordship. Then, Your Lordship may kindly come to this paragraph 7, Lordship. May I skip paragraph 7, Lordship? may come to paragraph 13, Lordship. In the stent case, Your Lordship, paragraph 13 I state that.
Yes.
In the stent case, it is not in dispute that the appellant was aged about 35 years and was working as a coolie and was earning rupees 4,500 per month at the time of accident. The claim is reduced by the tribunal to a sum of rupees 3,000 only on the assumption that wages of the laborer during the relevant period, that is in the year 2004, was rupees 100 per day. This assumption, in our view, has no basis. Before the tribunal thought, though the insurance company was served, it did not choose to appear before the court for the tribunal to have reduced the claim of the claimant and determine the monthly earnings to be a sum of 3,000 per month. Secondly, the appellant was working as a coolie, and therefore we cannot expect him to produce any documentary evidence to substantiate his claim. So, Your Lordship, in this case, Your Lordship, the income was taken as rupees 4,500 for a coolie.
Yes.
And court says documentary evidence is not expected in such case. Now, Your Lordship, number third judgment is 2014 2 SCC 735, says Sadiq versus Union. Your Lordship, it is at page 21. Well, he was a vegetable vendor, Your Lordship. He was a vegetable vendor. His income was taken as no documentary evidence was there. It was taken as 6,500 rupees. Your Lordship, may kindly come to para 8, Your Lordship. I'm reading, Your Lordship. The appellant, page number 27, Your Lordship. The appellant claimant in his appeal further claimed that he had been earning rupees 10,000 per month by doing vegetable vending work. The High Court, however, considered the loss of income at rupees 3,500 per month. Considering that the claimant did not produce any document to establish his loss of income, it is difficult for us to convince ourselves as to how a laborer involved in an unorganized sector doing his own business is expected to produce documents to prove his monthly income. In this context, in this regard, this judgment was referred. Then, Your Lordship, may kindly skip next paragraph, Your Lordship. Secondly, Your Lordship, it is quoted from other Supreme Court judgment, Your Lordship, that 13, it is written the last 4 lines, Your Lordship, 5 lines. Secondly, the appellant was working as a coolie, and therefore we cannot expect him to produce any documentary evidence to substantiate his claim. In the absence of any other evidence contrary to the claim made by the claimant, in our view, in the facts of the present case, the tribunal should have accepted the claim of the claimant. And in this way, Lordship, it was coming, I'm coming to last paragraph 9, Your Lordship. Therefore, there is no reason in the instant case for the tribunal and the High Court to ask for evidence of monthly income of the appellant claimant. On the other hand, going by the present state of economy and the rising prices in the agricultural products, we are inclined to believe that the vegetable vendor is reasonably capable of earning to be 6,500 per month.
So your submission is that the deceased in this case,
he was in an unorganized sector, and Your Lordship, doing a village, he was running some shop, and his brother was.
apart from mother, there is no evidence of his
He was working, that he was having this trading, this stationery shop and a farm. That farm was closed. This evidence has come.
My query is, the evidence is not there except mother.
Documentary evidence is
So
there. Yes.
listen to my query.
Yes.
Evidence is not there except mother said that 12,000 per month.
Yes. The Lordship says.
So the tribunal exercised its discretion and treated the income at 5,000. Now you want this appellate court to exercise, substitutes tribunal's discretion by its own discretion. But what is the basis?
Lordship, it is now.
Why
Lordship,
this
those judgments which I have cited, those are 15 years back. And Your Lordship, 15 years income and now income, Your Lordship. Lordship, it is lots of different. Now the Your Lordship, this income, your Lordship, 10,000,
No,
12,000.
the
these amount-
judgment, impugned judgment was passed in the year 2015.
Lordship. Lordship. So, your Lordship, now I am before your Lordship in 2026, your Lordship. That Lordship, your Lordship will check it.
So what is your submission?
My submission, your Lordship, the income which was taken by the tribunal, considering this status of different judgments which I have cited, it ought to have been at least, your Lordship, 8,000 rupees in the budget.
Okay.
This is one point. Your Lordship. Next, your Lordship, in this case, so far loss of consortium is concerned, after this present Megma General Insurance Company Limited, your Lordship, it is held that in any case, if there are three types of consortium, that is for parents, for children, for wife, these different types of.
But you are not children.
It should be 40,000. It should be taken for
No.
father and mother.
What kind of loss of
This
consortium?
is your filially, your Lordship, it is, Lordship, I am coming.
Filial.
It is filal consortium, your Lord. Filali consortium. I'm giving you, that judgment is there, Lordship. May kindly see page 67, your Lord. No, 69 it is.
Filial.
It's 67. It is Megma. Just a minute, Lordship. Megma, it is, your Lordship, my, that is page 57, Lordship, of my noting, your Lordship. Page 50, my serial page number 57. Lordship, may kindly see page 20, your Lordship. Three types of consortium are there. And each case, court says it should be 40,000. I'm reading paragraph 20, Lordship. MACT as well as High Court have not awarded any compensation with respect to loss of consortium and loss of estate, which are the other conventional head under which compensation is awarded in the event of death. Recognized by the constitutional bench in Panasati case, the Motor Vehicle Act is beneficial and welfare legislation. The court is duty bound and entitled to award.
No, therefore I am asking you, which loss of which consortium you are claiming?
Let that parental, because parents lost their child.
Parental consortium.
It comes, it will come, the court duty bound, Lordship, it may come.
Parental
Paragraph 21. Our filial compensation.
Parental consortium is granted to a child.
Filial consideration is awarded to parents. Your Lordship, may kindly come to paragraph 21, it is there. 21 point, your Lordship, if your Lordship go through, see 21.3. Next page, your Lordship, page 64. 21.3. Filial consortium is the right of the parents to compensation to the case of an accidental death of a child. This will come.
But what child means?
Child, for parents, every son and daughter, their child.
Irrespective of age.
Irrespective of age.
So at 34 years, he remains a child.
Yes, so for parent, it is for the parents, not for the child.
No.
Parents lost a young son. So there is love and affection, that part is there, your Lordship, for the child. Always it will be there. Even if I may be 60, your Lordship, for my parents, I will be always a child. And that is another judgment also, it is there, your Lordship. It is, Lordship. Now in all the, because your Lordship, because this judgment is, I have not brought any other, because in all the cases after this, your Lordship, in this honorable court, maximum cases 40,000 is given to the parents. If both parents are surviving, the 40,000 each is given. If your Lordship, there are so many judgments after this, your Lordship. So Lordship, filial consortium is the right of the parents to compensation in the case of an accident, death of a child. An accident leading to death of a child causes great shock and agony to the parents and family of the deceased. The greatest agony for the parent is to lose their child during their lifetime. Children are valued for their love, affection, companionship, and their role in the family unit.
No, this, to my understanding, relates to children. But children may, child means the child relates to a particular age. You may be son or daughter, but you do not remain child throughout your life.
Your Lordship, this
After attaining majority, you are no longer child. You may continue to be son or daughter. That is how I understand.
Lordship,
If I
then
am wrong.
I will some second half I will submit so many judgment.
Okay.
All the cases court is giving 40,000 whenever any person is dying, parents are surviving. There's so many judgment. Lordship.
No, whether it answers my query.
Yes, that is no, but your Lordship, whether a child is whether a son is 12 years or 60 years, Your Lordship, this love, affection, and companionship, these things will always be there for the parents. And their role in the family.
So filial consortium has to be granted irrespective of age of son or daughter.
That is my humble submission.
Okay.
And Lordship, may kindly come to paragraph 24, your Lordship, in this case, your Lordship. Paragraph 28. The amount, paragraph 24, the amount of compensation to be awarded as consortium will be governed by the principle of awarding compensation under laws of consortium as laid down in the Pranasati. In the present case, we deem it appropriate to award the father and sister of the deceased.
Mr. Jain, what I want to understand, whether filial consortium can be granted for loss of a son or daughter, irrespective of his or her age.
Lordship, in this case, let us see, Your Lordship, what is the age of the deceased in this case. How many?
In magma,
Segment. Just I'm telling you. Here, this is
Yes,
24
later.
years in
Okay.
paragraph.
Okay.
Paragraph 5.
So your
24
submission
years.
is that though in para 20, the phrase child has been used.
Child is used. Your Lordship,
It does not
it should be
literally
taken.
means child. It means son or daughter.
That's it. So far, paragraph 5
Okay,
where is
okay,
concerned.
okay.
He was 24 years of age. And my case is one other point was also there. I was bachelor.
So therefore what?
The bachelor, you are married, then Lordship, this love and affection, it is distributed. But it is, Lordship, I will
Bachelor
submit when he is
remains a
bachelor.
child forever.
Yes,
Is it your submission?
if my parents are alive, I am child for them.
I am unable to agree.
Lordship, here, Lordship, in paragraph 5, it is age of 24 years.
Yes, this I will clarify in this judgment.
Paragraph 5.
Yes. Anything else?
Lordship. Apart from this, Your Lordship, these 2 points I have taken. Then, Your Lordship, so far this is concerned, loss of, this one was taken 5,000.
Loss of estate.
Loss of estate. Now it is, Your Lordship, as a penalty case, it is, Your Lordship,
15,000.
15,000. And it should be multiplied, it should be increased every 3 years by
Yes.
every 3 years it should be increased. So it is now 6 years that judgment was.
No. The Pranay Sethi's judgment came in the year 2017.
So
And this judgment was passed in 2015, 2 years prior to.
what is applicable today, Your Lordship, that will be applicable, Lordship. That is my humble submission. Because, Your Lordship, just now, my learned friend submitted, so far the deduction is concerned for the, previously it was 50% for future prospect, was 50% for all the cases. Pharmaceutic came very later. In that case, it is held that for the organized sector, it is very job is permanent, it is 50. For
No.
self-employed, it is 40. Now he's taken.
By that argument also, that 10% increase of the
This
loss of consortium, loss of estate
Yes.
starts from 2017.
Okay, Lordship, 2000, it may be taken, Lordship. So every 3 years. So my case is now it is 17, 20, 23, 26.
No, the assessment has to be on the date of death of the deceased, not at the date when we are computing the.
I could not understand, Lordship.
That 10% increase is not on the date when compensation is awarded. It is on the date when the deceased die.
No, Lordship,
If deceased, suppose deceased died in the year 2023, then 6 years have lapsed after 17. He will get a 20% increase. Okay.
that is my submission.
Okay. What else is your submission? Anything else?
After 17, 10% every 3 years it should.
Okay. Anything else?
Yes, Lordship. Then general expenses get over here also. And so far interest is concerned, Your Lordship, it was awarded 6%, Lordship. I'm giving 3 judgment, Lordship, of this honorable court also. Your Lordship, I am coming to that is. And Lordship, that judgment, the degree of proof in the MD cases, Your Lordship, because regarding documentary evidence, Your Lordship, as I have submitted, Lordship, that it is not necessary in all the cases when the people who are unorganized sector doing business in village or doing small traders.
Okay.
And for that, Your Lordship, 1995-1 GLT 216, Your Lordship, which followed 1980 Supreme Court, Your Lordship, page 67, Your Lordship, that judgment is there. Union of India versus Mrs. Saraswati Devnath, 1995-1 GLT, page 216, paragraph 6, Your Lordship.
Okay.
Lordship, may kindly come to page 67 of my noting, Lordship.
No, I'll go through it. Your submission is that the documentary evidence is not necessary for unorganized sector.
Means small traders, it is not necessary.
Okay.
Or it cannot be expired, Your Lordship. It is only after 2019, Your Lordship, after this COVID and all. Now it is online and all these things are happening. Previously, Your Lordship, it is.
Okay. And
Your Lordship, this judgment so far 1995, 1995.
And what is your submission? Interest should be at the rate of 9%. 9%.
Uncle.
9%.
Yeah, Lordship. That my humble submission, Lordship. I am citing on judgment of 2015-14 SCC 353, Narendra Singh's judgment, page 69, Lordship. 69 of my noting, Lordship.
Okay.
9% is, Lordship. My humble submission after this, it should be at least 9%, Lordship. And this judgment is also in that line. Lordship, may kindly come to directly paragraph 15, Lordship, of this judgment.
Okay.
My noting page 76, Lordship. Further, Lordship, got it?
Yes.
Further, an interest at the rate of 6% per annum on the compensation was awarded by the tribunal, which was enhanced to 7.5% by the High Court. The interest rate determined by both the court below are bad in law as per the legal principle laid down in MCD versus Upahar Tragedy Victims, Assam. Whereas this court has awarded interest at the rate of 9% per annum on the compensation awarded in favor of the appellant, applying the same legal.
What is the basis of imposing interest? 9%. What was the basis?
Lordship,
Bank rate of interest.
Lordship, prevailing bank rate, lending rate on.
Okay.
So, Lordship, applying the same legal principle, we grant interest at the rate of 9% per annum on the compensation awarded. Then another judgment, Your Lordship, may kindly see It is at page 72, Your Lordship. 2022 6 GLT, page 89. New India Assurance Company Limited versus Lata Agarwal. Your Lordship, this is in this case, Your Lordship, the Honorable Court compared the interest awarded in WC Act, different act. Your Lordship, it is 12% mandatory, Your Lordship. Some other acts, in many cases, the court has referred. I am coming to paragraph 17, Your Lordship, you kindly see.
What was the bank lending rate interest in the year 2015?
Lordship, that is to find out, Your Lordship.
Okay.
But Your Lordship, paragraph 17, if Your Lordship see, Your Lordship, in this grant of interest in different acts, it has been written, Your Lordship, different act, what is, it is more than 9% in those acts. So court said why it can't be in the present case. It is a motor vehicle act case, Your Lordship, in this, Your Lordship, paragraph, Your Lordship, I'm coming paragraph 70. And the court in this case awarded interest, Your Lordship, at the rate of 9%, after considering all other acts, Your Lordship. Paragraph 9, Your Lordship. Be that as it may, this court, in view of the findings above mentioned, directs the modified award of rupees shall carry an interest of 9% per annum from the date of filing of the claim petition. This is the. And before that, instead of reading, just I like to point out, Your Lordship, from paragraph 17 to 23. These are the different acts were discussed and different judgments were discussed. And the court said the 9% is reasonable, Your Lordship.
Okay.
And another judgment, Your Lordship. Lordship, this Gauhati High Court, Your Lordship, it is 2023 6 GLT, page 23, Your Lordship, 523. My noting is page 991, Your Lordship. Your Lordship may directly come to paragraph 12, Your Lordship. At page 102, serial page, Your Lordship.
Yes, yes.
The last ground of appeal raised by the appellant insurer is that the 9% interest per annum awarded on the compensation amount is unreasonable and in violation of the law, and only 6% interest should have been awarded. The appellant has, however, not justified as to why 9% interest per annum should be reduced to 6% per annum. Section 171 of the Motor Vehicle Act 1988 provides that where any claim tribunal, where the claims tribunal allows a claim for compensation made under the Act, such tribunal may direct that in addition to the amount of compensation, simple interest shall also be paid at such rate and from such date not earlier than the date of making of the claim, as it may specify in this behalf. In the present case, the learned tribunal has awarded rupees 14 lakhs an hour as compensation, which also includes the interest award of rupees 25,000, and the appellant insurance has been directed to pay the compensation with interest at the rate of 9% from the date of filing of the claim petition till full satisfaction of the award, and the appellant has been directed to pay the compensation within 1 month from the date of the order. That direction of the tribunal to pay 9% interest per annum on the awarded amount is in conformity with the mandate of Section 171 of the MB Act 1988. This court, therefore, does not find any infirmity with the finding of the tribunal to pay 9% interest per annum on the awarded amount. So, in nutshell, my submission will be, Your Lordship, the interest should be at least, Your Lordship, 9% in this case. Okay.
Yes, Mr. Saki.
So far future prospect is concerned, Your Lordship. Future prospect is concerned, Your Lordship. So far, this interest on future prospect is concerned. Interest on future prospect is concerned. Your Lordship, though this High Court, Your Lordship, there are 4 or 5 judgments, because one judgment was given initially without any reasoning, and the court, every court is following that judgment. And so far Supreme Court is concerned, I have not come across a single judgment, not a single judgment, Your Lordship, where future prospect interest was not given. It is only and no other high court also. I have come across only this honorable court, your lordship, first judgment came without any reasoning on the submission of the council, it was reduced and it was given that.
No, but there are some judgments where reasons are given
Isn't
that
it proper,
future prospect accrues on a future date
lordship?
and therefore it
Lordship.
does not carry any interest.
Lordship, person when dies, his multiplier is taken suppose 15. This income also is payable for future income, your lordship. This is also future. Everything on future, depending on future, lordship. Everything depending on future. That is my humble submission, your lordship. And lordship, so far this point is concerned, your lordship, I will, I will not, I'm not saying too much, man, your lordship. I say that this point is a fit point where this may be referred to the larger bench. Because, your lordship, not a single Supreme Court judgment, no any other High Court judgment till now says that the future prospect interest will not. It is only our High Court. And because, your lordship, all single bench judgment, your lordship, which are delivered by this court, your lordship. So for that limitation is there, I understand, lordship. So if your lordship finding
No,
this,
then I have to differ with the reasons given in the judgment cited by learned counsel for the appellant.
appellant cited only in all the cases, this,
Champavati.
not only this High Court judgments were cited.
Yes,
No any other judgment
this
was
High
cited.
Court judgment is binding unless I differ.
Lordship, that I submit, your lordship, because somewhere, because when claimant get compensation, they don't go for a Supreme Court. Even, if no compensation is given, they don't, very rarely they go to Supreme Court. So this point, your lordship, because of this High Court judgment, your lordship, that coming in the way, and lordship, my humble submission is if your lordship may differ on this point, your lordship.
Why should I differ? You give a good reason.
That is
But-
submitting, not a single Supreme Court judgment, not a
No,
single.
that in itself cannot be a reason for you. The reasoning given is that the future prospect is relatable to an income to be received in future, and as such there could not be any loss to the claimant for payment of future prospect. Future prospect is something which the deceased would have got in future, and therefore it cannot carry any interest. That is the reasoning. You overcome this reasoning. What is it?
Future, suppose my income is suppose 5,000.
Yes.
So for future prospect is concerned, it is taken already, it is taken so for 50,000 or 40,000 after pronouncing this case, now it is 40,000 after pronouncing 40%. Previously it was 50%. So already income is scaled down to this, it came to 50% already. That taken interest part is taken care of here. When the compensation, if my income is 5,000 for future, it is taken only 2,500. And a man of 35 years, he could have survived at least 60 years, lordship. And that's why 15 multiplier is there.
Okay. Yes, Mr. Sir. Anything else?
So in all the compensation awarded, why not in future prospect, lordship? I fail to understand. And lordship, this is the reason given in all the cases, which lordship just 2 lines. And lordship, my humble submission is this required a reconsideration. Much obliged.
Yes, Mr. Saki. Anything?
Lordship, regarding income, Lordship, income which was this accident is of 2007. At that point of time, Lordship, minimum wage was taken in between 50 rupees to 75 rupees per day. Now, in this case, Lordship, as the accident took place in the 2007, the honorable, this honorable court may take income of the person at that point of time. So at that point of time, Lordship, 5,000 was quite reasonable. And in this regard, Lordship, one decision of this Honorable High Court is also there, which says that this accident took place in the year 2010. The decision I'm citing this before, Lordship. In this case, 5,000 income was taken into consideration, accident of 2010. In the 2010 also, Lordship, it was taken as rupees 5,000 was quite reasonable. Lordship, paragraph 10, paragraph 12, 13.
Well, 13, what is the reason? Only reasoning is binding on this court, not what
Yes, Lordship,
in
reasoning.
in this judgment, no reasoning is given.
Salary certificate was, Lordship, submitted, but that was not duly proved, Lordship. So at the time of accident, which is in the year 2010, the rupees 5,000 was considered to be a reasonable one, Lordship.
Okay.
Lordship, on internet search, Lordship, I have found, Lordship, that at that point of time, 2007, Lordship, the minimum wage was considered as a rupees in between 50 to 75 rupees per day, Lordship. That may, Lordship, also have a look, Lordship.
Okay.
Regarding, Lordship, interest, Lordship, 6% interest is reasonable at that point of time, Lordship. It depends upon the state of economy and the rate of interest fixed by the Reserve Bank of India, Lordship. At this point of time, now it is much less than that also. At earlier point of time, it was much, but 6% at that point of time in 2007, then the husband in 2005, 2015, Lordship. This is quite reasonable, Lordship.
Heard. Mr. A.J. Sakya, the learned counsel for the appellant. Also heard Mr. B. Jain.
BKJ.
B.K. Jain, learned counsel for the respondent. You are also there. Also heard Mr. J. Ahmed, appearing for respondent number 6 and 7. In cross objection also you are 6 and 7.
Cross objection, Your Lordship, memo, cross objection will receive.
Proposition, he will be, Lordship, 2 and 3, but he has not received copy. He has submitted.
Six and 7 in the appeal, as well as respondent number 2 and 3 in the cross objection. 2 and you are appearing for whom?
Girish Chandra Vaishya and Pavitra Vaishya.
Christian questions. And the cross objection. By this common judgment, this court proposes to dispose of the MAC appeal number 214/2016, as well as cross objection filed therein. That is cross objection number 15/2017.
I very clearly installed.
No, you don't have any submission in this case. Who is to pay the
Trial court passed the judgment that
against the
whatever
appeal?
is payable by the insurance
Appellant.
company, they can recover from him.
Okay.
Because their allegation was it was a fake license. It was fake license, which point now perhaps they have given up. In view of the service.
But you have not preferred any appeal.
Yes, Lord.
No, you have not preferred.
So do that. So do that.
It is a case of pay and recovery.
Yes, Lordship.
Pay and recovery.
Yes.
And you have not challenged that. Stop. This appeal.
In this regard, Lordship, I have given two judgments. That was maybe servicing case, that is that. No, not taken. No, I am not. Because they have not raised that point now.
Yes.
Because previously there is one ground that they are not liable, but that point they have given up here.
That trial court judgment, Lordship, of pay and recovery is still exists, Lordship.
That
We are not challenging. So we will get that recovered from the owner, Lordship.
Okay, that issue is not before this court.
Yes.
Because no one has challenged that.
That trial court observation
And
is still
last-
there, Lordship.
Last.
It is not under challenge.
Stop. The MAC appeal number 214/2016 has been filed by the appellant United India Insurance Company Limited under section 173 of Motor Vehicles Act 1988, impugning the judgment and award dated 6/10/2015 passed by the Motor Accident Claims Tribunal number 2, Kamrup, Assam, Kamrup, Guwahati in MAC case number 393/2011, whereby the present appellant was directed to pay a compensation amount of rupees 7,50,000 to the claimants with an interest at the rate of 6% per annum from the date of filing of the claim petition and till realization. Where is that pay and recovery observation?
Lordship, page 14 of the running page 14 of judgment, Lordship, of my MSc appeal.
Which pair?
Paragraph 4. It is settled law.
Stop. The appellant was also given a liberty to recover the compensation paid to the claimant from the owner/insured in according to due process of law by the impugned judgment. The appellant insurance company is aggrieved with the quantum of compensation paid to the claimants. On the other hand, the claimants/respondent have also filed the cross objection number 15/2017, impugning the aforesaid judgment and award. They are also mainly aggrieved with the quantum of compensation awarded to them, asserting that the said quantum is on the lower side. Stop. The facts, next para, the facts relevant for consideration of the aforesaid appeal, consideration of the instant appeal / cross objection, comma, in brief, comma, is that, are that on 16/3/2007 at about 8 p.m. the son of the claimants, namely son of the claimant number 1,
One and two,
2 is wife or sister.
wife.
Your lordship, one is mother, father, say two is mother, and 3 to 5 are brothers.
Okay.
One is wife of, two is one, wife
But
of
this
one.
appeal is by 1 and 2 only. Cross objection has not been.
Cross objection by all this, cross objection is by mother. All, lordship, all they have filed. All the claimant.
The son / brother of the claimants, namely late Pradeep Deka, was coming from Mukalmua to his home on his bicycle on 16/3/2007. Stop. At that time, a vehicle bearing registration number AS14A8545 coming from the same direction in a rash and negligent manner knocked him from backside, causing grievous injuries on his person, resulting in his death on the spot. Stop. After the death of the late Pradeep Deka in the aforesaid vehicular accident, the parents and siblings of the deceased approached the Motor Accident Claims Tribunal number 1, Kamrup, by filing an application under Section 166 of the Motor Vehicles Act 1988, seeking compensation for death of their son / brother. Stop. The insurance company, the appellant insurance company contested the claim of the claimants by filing written statement. The owner and the driver, within bracket respondent number 6 and 7 in the appeal, bracket close. You also contested.
They are not. They are not.
They did not contest the case before the tribunal, and as such, the inquiry proceeded ex parte against them before the Motor Accident Claims Tribunal. On the basis of the pleadings of both the parties, the Motor Accident Claims Tribunal framed following issues. quote A from page number 10 of the memo of appeal. During the inquiry, the claimant side examined two witnesses and exhibited certain documents. The insurance company, that is the present appellant, also examined two witnesses in support of their case. Stop. However, by the judgment and award impugned, judgment and award dated 6/10/2015, passed in MAC case number 393/2011, the Motor Accident Claims Tribunal, Kamrup, Gauhati, allowed the claim of the claimants and directed the present appellant to pay the compensation to the claimants in the manner as already described in the foregoing paragraph of this judgment. Stop. Next paragraph. Mr. A.J. Saikya, the learned counsel for the appellant, has submitted that the Motor Accident Claims Tribunal has submitted that the appellant insurance company is basically aggrieved with the quantum of compensation awarded to the claimants by the Motor Accident Claims Tribunal. He submits that. Stop. He, however, fairly submits that though one of the ground taken in the memo of appeal was that the tribunal has erred in not selecting the proper multiplier on the basis of age of the parents. He sentence to production. However, in view of the judgment of the apex court in the case of PROCEEDINGS versus in the case of National Insurance Company Limited versus PROCEEDINGS and others, reported in 2017-16 SCC 680, he is not pressing the said ground as the law has been clarified by the apex court that it is the age of the deceased which has to be taken into consideration while selecting the multiplier for assessing the compensation to be paid to the claimants. Stop. Learned counsel for the appellant has further submitted that the tribunal has erred in adding 50% of the income of the deceased towards future prospects, as the law has been clarified by the apex court in the case of PROCEEDINGS within bracket supra, that in case where the deceased was a self-employed person, an addition of only 40% of his established income should be there when the deceased is below the age of 40%. He submits that in the instant case the deceased was of 34, how much? What was the age?
About 34 years.
Was about 34 years of age at the time of his death and was engaged, was doing his own business, and as such, as per the mandate of the Apex Court, the addition of 40% was only warranted to addition of 40% to his established income was warranted and not 50% as has been done by the tribunal. As such, he submits that the compensation awarded to the claimant may be reassessed after adding 40% of the income as future prospect instead of 50% as has been done by the tribunal. Stop. Next para. He further submits that the Motor Accident Claims Tribunal also erred in awarding interest also to the future prospect awarding interest to the awarding interest on the future prospect, which could not have been done in view of the judgment of the coordinate benches of this court in several cases. He submits that in the case of Khushbu Chirania, alias Kanta Chirania versus Kamal Kumar Sova Saria, reported in 2018 0 Supreme within bracket GAU 966, and in case of, as well as in case of Nasima Begum versus Keramat Ali, reported in 2019 0 Supreme GAU 507, and case of Oriental Insurance Company Limited versus Srimati Champavati Ray and others, within bracket judgment dated 1/9/2019 in MAC appeal number 378/2017. It has been held by this court that there cannot be any interest on future prospect, as same relates to an income to be given in future. Stop. He submits that as such, the tribunal also erred in the, as such, he also submits that as such, the compensation awarded to the claimant has to be reassessed by deducting the interest awarded on future prospect therefrom. Stop. What else was your submission apart from this future? Any other point?
In my appeal,
These are the
and
points.
Brothers and sisters are made claimants, but they are not dependent. It is evidence on record also.
They were granted compensation or not?
Not given.
They were not given.
Yes.
Mother was considered.
Mother and father.
Father was asked.
Only
was-
mother of
The 7 lakh has been paid only to mother.
mother.
So far this, it was taken, only mother is dependent as per this.
Loss of dependency
Loss of dependency.
and loss of consortium.
That is to be given to both the parents.
Okay, okay. Stop. On the other hand, Mr. B.K. Jain, learned counsel for the claimant / cross objector, submits that though the tribunal has allowed the claim petition filed by the claimants, however, it has assessed the compensation awarded to them on a lower side, and same is required to be enhanced. He submits that the income of the deceased was taken on a lower side by the tribunal at rupees 5,000 per month only, whereas there was clear evidence on record that the deceased was engaged in business of poultry farm, as well as he also used to assist in the business of stationery shop of their family. He also submits that the mother of the deceased has categorically stated in her deposition that the deceased used to earn rupees 12,000 per month from his business. He submits that the tribunal had assessed the income of the deceased at rupees 5,000 only, as no documentary evidence could be adduced by the claimant side. However, he submits that as the deceased was engaged in a small business of poultry farm and stationery shop, he is not supposed to maintain any documents to prove his income. And in this regard, he submits that the requirement of adducing evidence similar to that of a civil suit is not there, and his income, considering the nature of business in which he was engaged, should be taken at least at the rate of rupees 8,000 per month. In support of his submission, learned counsel for the claimant slash cross objector has cited following rulings. Rama Chandrappa versus Royal Sundaram Alliance Insurance Company Limited, reported in 2011, 13 SCC 236. Syed Sadiq versus Union of India, 2014, reported in 2014, 2 SCC 735. Sono Banu versus Ahmedabad Municipal Transport Service, reported in 2013, 16 SCC 719. Learned counsel for the claimant slash cross objector, however, fairly submits that the addition towards future prospect ought to have been at the rate of 40% of the established income of the deceased as held by the apex court in the case of Pranay Sethi Supra. He, however, learned counsel for the claimant slash cross objector, however, submits that the tribunal has erred in not awarding any compensation against loss of consortium to the claimants. He submits that the claimant number 1 and 2, being parents of the deceased, and claimant number 3, 4, and 5, being siblings of the deceased, are entitled to consortium, are entitled to compensation on account of loss of filial consortium at the rate of 40,000 each, as held by the apex court in the case of Pranay Sethi versus Pranay Sethi Supra, as well as in the case of Magma General Insurance Company Limited versus Nanu Ram, alias Churu Ram, and others, reported in 2018, 18 SCC 130. Learned counsel for the petition, learned counsel for the claimant slash cross objector further submits that the tribunal also erred in awarding an interest at the rate of 6% per annum only on the awarded amount, which is on a much lower side he submits that the apex court and some coordinate benches of this court have awarded much higher interest at the rate of 9% per annum in many cases under similar circumstances. In support of his submission, he has cited following rulings. Narendra Singh versus Nishant Sharma, reported in 2015-14 SEC 353. New India number 2, New India Assurance Company Limited versus Lata Agarwal and others, reported in 2022 6 GLT 89. Next, branch manager Cholamandalam versus Jitu Bura Gohai, reported in 2023 6 GLT 2023. He therefore submits that in view of the aforesaid rulings of the apex court / coordinate bench of this court, the interest awarded on the compensation amount should be enhanced to 9% per annum instead of 6%, which has been awarded by the tribunal. He also submits that though in some of the cases by a few coordinate benches of this court, it was held that no interest ought to have been awarded on future prospect, as the same relates to an income to be given in future. However, he submits that in most of the cases, even the apex court has not discriminated in this matter and has awarded interest on the entire awarded amount, including the future prospect. He therefore submits that the compensation, the interest should also be awarded on future prospect. And for the same said purpose, if it is required, the matter may be referred to a larger bench of this court so that the questions on awarding interest on future prospect may be settled for all times to come. Stop. Learned. Anything else?
So if we state 5,000, it should be 15,000 plus
Yes.
increase after every 3 years.
He also submits that the compensation awarded against loss of estate is also at a lower side, that is at only 5,000, only rupees 5,000 has been awarded, whereas the same ought to have been at the rate of 50 rupees 15,000 as settled by the apex court in the case of PROCEEDINGS within brackets Supra.
One more point, Your Lordship, though my learned friend he did not take funeral expenses, I was awarded 25, it ought to 50. That
He also fairly submits that
15,000.
Though the compensation awarded against funeral expense is at is 20 rupees 25,000, same may have to be reduced to rupees 15,000 in terms of the judgment of the apex court in the case of Pranay. Yes, Mr. Ahmed, you don't have anything.
They are not any allegation on their having license defect on a valid flag. There is no place. They should prove that driving license is not valid. That place not. They register. And all the insurance paper we submitted the registration paper. So that our vehicle has been insured with that. So they are liable to it. If the driving license is they should prove it. But no, nothing has been there. So no amount is to be recovered from the.
Stop. Mr. J. Ahmed, learned counsel for respondent number 6 and 7, that is owner and driver of the offending vehicle, submits that though owner and driver of the offending vehicle did not contest the claim case before the Motor Accident Claims Tribunal, neither they preferred any appeal against the impugned judgment and award. However, they should not be made liable to pay the amount to the insurance company, as the insurance company has failed to show anything, failed to show anything that there was any breach of policy condition by the owner or driver of the offending vehicle. Neither there is anything on record to show that the driving license of the driver was fake or invalid star. He also submits that in the written statement filed by the present appellant before the Motor Accident Claims Tribunal, no such plea was taken by the insurance company. Hence, he submits that the direction of the Motor Accident Claims Tribunal in the impugned order that the amount payable by the compensation payable by the insurance company to the claimant is recoverable from the respondent number 6 and 7 needs to be modified. Stop. I have considered the submissions. While replying to the submissions made by the learned counsel for the cross objector / claimants, the learned counsel for the appellant, Mr. A.J. Saikya, submits that in absence of any proof of earning, concrete proof of earning of the deceased, the tribunal has rightly assessed the income of the deceased at rupees 5,000, considering the rate of inflation and other factors at the time of death of the deceased, that is in the year 2007, when the daily wage of an unskilled worker was about rupees 50 to rupees 75 only. And he, as such, he submits that the the no interference should be made by this court on the assessment of daily income of the deceased by the tribunal. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. Stop. I have also gone through the rulings cited by learned counsel for both sides in support of their respective submissions. ... Reserved. Heard so and so. Hearing concluded, judgment reserved.
Exhibit 8 and 9, two documents are there so far my working itself. Exhibit 8 and 9.
Ek line neat hoy dibu. Learned counsel for the cross objector also submits that Exhibit 8 and Exhibit 9 clearly shows that the deceased was engaged in the business of poultry farm as well as in the stationery shop, which is sufficient for the purpose of assessing his income at the time of his death. Stop.
Also PW2 teacher. His teacher, he also. Regarding my
He
occupation.
also submits that apart from the mother of the deceased, the independent witness, that is, who was examined as PW2, also deposed regarding the business in which the deceased was engaged. ये ऊपर जाएगा. हाँ? Okay. Judgment is yes. Yes, Mr. Aman.
In this case, we have challenged the quantum of error.
Quantum.
Let's see. First thing is the monthly income was considered at 6,000. It is a case of 2014, let's see. And regarding loss of earning capacity also, we have challenged, let's see. May I read the judgment? Let's see.
Yes. No. Whoa. Income on what ground you are challenging?
Yes, let's see.
Income, what is your ground?
Let's see. My ground is that at the relevant time of accident or an unskilled labor, as per the Assam government's income was received 4,394.
Okay.
But it was considered 6,000.
And what was the proof of income?
There was no proof, let's say.
No proof.
Only, let's say, one concert certificate was given. He was doing work in a stone quarry, let's say. No one was examined from that, let's say. Right? May I read the judgment, let's say?
Yes.
Let's start from 14, let's say.
No, instead of okay, read.
Of para number.
So one ground is that in absence of any proof of income,
Let's see.
the court, the
Okay,
tribunal
that's
ought to have considered the notification
Yes.
regarding
Minimum wage.
minimum. There was a prevalent notification at that point of time.
Yes, let's say I have annexed, let's see.
At page
Annex A, let's see.
page
13, let's see.
page
13, let's see. Annexure A.
Page 8.
Schedule, Lordship will find a schedule, categories of workmen, rate of wages, Lordship, skilled workmen, rupees 227, skilled workmen on the other than ITI certificate holder, 175, and unskilled workmen, rupees 169.
Where are you reading?
And next, Lordship, first page, Lordship will find.
Page 7. It is
Yes.
not.
In exercise of power conferred by subsection B of the clause 5 of subgroup.
So when the accident occurred?
Accident occurred 7/4/2014.
So this notification was prevalent.
Yes, so this was forced at that time.
160. What?
1 March 2013. Also.
It is daily wages is given.
Yes, let's see.
How much it comes on monthly?
So the working days is 26 days. Let's see. If it is calculated, then it's come to rupees 4,394.
Why 26 days only?
Let's see, as per the notification, let's see.
Where?
Holidays, hours of work and condition, service to the contract workers required under sub-rule 2, Rule 25 of the contract labor, Assam Rules 1979 shall be hereunder.
One 169 into 30. How much it
Let's see.
comes? Okay. What else is your submission? This is one part. Other part is?
Other passage, let's see, regarding the disability, it was not properly put. Regarding disability. The medical certificate was issued by the Silchar Medical College, and in the cross-examination, it was admitted that the certificate was not issued by duly constituted medical board in terms of the guideline by the Ministry of Social Justice and Empowerment. And in the certificate, there was only two signatures, let's say. The mandatory requirement of the certification by a board consisting of 3 members, that was not there. No member of the medical board was examined to prove the disability certificate.
Okay.
And that doctor who was examined, he let's say find that he has no personal how the disability was assessed. And regarding the disability and loss of earning is not similar, let's say, not synonymous, let's say. Disability was, let's say, assuming that the disability was 50%. Even then also, loss of earning capacity cannot be 50%, let's say.
What he was doing earlier?
He was doing.
Why? Disability on account of what? What injury he
He
suffered?
was doing work in the stone quarry. We can do
What was the disability?
fracture of leg, let's say.
Only fracture.
Let's say.
Okay. Fracture caused permanent disability.
As part of, let's say, certificate, let's say, that was permanent disability. But the doctor who was examined, let's say, he has no personal how the disability was assessed, let's say.
Okay, make your submissions.
And there was no evidence, let's say, from their side that a complete inability to work or inability to undertake alternative employment or inability to engage in agriculture, business, or other occupation. There is no evidence to that effect.
Okay.
And here also no evidence to show that he was permanently incapacitated from earning livelihood. So my humble submission is that loss of earning capacity, maybe it may be 20%, not 50%.
Where is the assessment of loss of earning capacity by the tribunal in the judgment? Which para?
Page number, let's see the internal page of the judgment is page number 6. Let's see
6.
6.
Which?
Let's see in the last part also we'll find the PW2 medical officer being registered of orthopedics department deposed that claimant was diagnosed as a case of type of 3B compound fracture both bone distal leg left with degloving injury following Ellie's history of
Degloving injury.
degloving following Ellie's history of road traffic accident on 7/4/2014. He was treated with own debridement with external fixation application on 10/4/2014. Exhibit 3 is another discharge certificate of SMCH which transferred that claimant was again admitted on 22/5/2014 and was discharged on 4/6/2014. The PW3 being medical officer of surgery department deposed that claimant was diagnosed as a raw area of left foot. External fixation applied from orthopedic department and was treated the split skin grafting under local anesthesia on 22/5/2014. Exit 4 is another discharge certificate of SMCH which transferred that the claimant was admitted on 8/8/2014 and was discharged on 29/8/2014. PW2 being medical officer of the orthopedic department deposed that the claimant was diagnosed of non-union of fracture that is type 3B compound fracture both bone distal left leg. The PW2 further deposed that the condition of the claimant was unsafe and he was planned for reserve operation. Claimant also produced one disability certificate, height exhibit 9, on perusal of which the PW deposed that the disability certificate issued from the orthopedic departments of SMCH, which transferred that claimant is permanently physically disabled to the extent of 50% in relation to the left lower limb. Since both the medical officer are authorized by the SMCH authority to depose in the case and they depose as expert in the medical field, I have no reason to disbelieve the evidence of PW2 and PW3. Learned counsel for the insurance company during arguments that the disability certificate was not issued by any medical board, but a single doctor issued the said certificate. But as per notification number HLJ 729982013 dated 1st February 2013, issued by the Governor of Assam, in case of single disability, one specialist doctor working in government hospital is authorized to issue disability certificate. On perusal of Exhibit 9, it is found that it has been issued by Dr. A.K. Sipani, Professor of Orthopedics. Hence, I see no irregularity in the issue of disability certificate. Therefore, the document exhibit by one claimant cited then corroboration to the fact that the claimant sustained permanent disability of 50% out of the injuries sustained in a motor vehicle accident that had occurred on 7/4/2014. Under a jurisdiction of Barokola PS, the answering insurance company do cross-examine the PW1 and PW2 and PW3 at length, but it failed to controvert the evidence of PW3 coupled with documentaries to negate the fact of the accident arising out of rash and negligent driving by the driver of the offending vehicle, resulting in injuries and permanent disability on the person of the claimant. Since the claimant side discharged the burden of proof with the help of police paper, the accident occurred due to rash and negligent by the driver of the offending vehicle. It is the duty of the insurance company or the owner of the vehicle to negate the fact of accident or that there was no rash and negligent driving on the part of the driver of the offending vehicle. But the answering also did not discharge his burden to negate the case of the claim. In such a circumstance, we have to believe the case of the claimant projected in the claim which is substantiated by the evidence of PW1, PW2, and PW3. So relying upon the testimonies of PWs as well as relying upon the exhibited document, the issue number 1 and 2 are decided in favor of the claimant, holding a claimant sustained injury and consequent permanent disability as a result of vehicle accident occurred on 7/4/2014 under the jurisdiction of Borgula Peace, and the accident occurred due to a rash and negligent driving by the driver of the vehicle. Prepared that verification so and so. In view of affirmative decision of the issue number 1 and 2, the claimant found entitled to compensation to assess compensation in personal injury case arising out of rash and negligent driving of the motor vehicle while awarding compensation. The Honorable Supreme Court in case of Sanjay Kumar versus Ashok Kumar and reported into so and so held the head under the compensation awarded as follows.
No, where is the observation regarding functional disability? Loss of earning capacity. No discussion.
No discussion, Lordship.
Okay.
Only Lordship, para number 13, it was read that, Lordship, para number 13. Claimant claimed that he was a day laborer and was earning rupees 6,000 per month. In support, he produced 2 income certificates from Gaon Pansat and Circle Officer marked as Exhibit 10 and 11 respectively. Gaon Pansat is not the proper authority to issue income certificate, but at the same time, Lordship, kindly see the Exhibit 11, Lordship,
Yes.
when it was issued, Lordship.
When?
It was issued by the Circle Officer in the year 2017, Lordship. As per the same certificate also, the claimant has earning in the year 2017, Lordship. So there was no loss of earning. Exhibit 11.
You have annexed it.
It's in a market record. I have.
Exhibit file. Exhibit file. Attach files.
Yes, sir.
When accident occurred?
Accident occurred on 7/4/2014. And this certificate was issued on 12/12/2017.
How much he was earning?
As per this certificate also, it was 72,000 after the accident also.
That is per month.
Per month, 6,000.
So there is no loss of earning.
No
That is okay.
As per the, it is their document also. They have exhibited it. So my humble submission is that there was no loss of earning. And let's say, even there was loss of earning, that should be not 50%, at maybe 20%.
On what basis? How?
Let's say some injury was there, let's say. Some injury, he may not be able to work in the stone quarry, but he can do another field, let's say.
But 11 shows that he was earning 6,000 per month in the year 2017.
So as per the, there is no loss of earning, let's say. There is no loss of earning, let's say. So he was doing work as per their evidence also, documentary evidence.
Yes. Anything else? Any judgment? Anything else?
No, Lordship. There is no law surrounding in this case, Lordship.
Yes, Mr. Talukdar.
Lordship, so far as the notification as mentioned by my learned friend, in the notification itself, it is stated minimum wage. It should not be less than that in any circumstances. Lordship, kindly see notification annexed as Annexure A. It is specifically mentioned, Lordship. Annexure A schedule is there. Below schedule, column C, unskilled workman, ₹169. And then after skipping 2 lines, it has been mentioned this rate of wages shall be fixed in such a manner that no unskilled workman gets less than 169 per day. It is not mentioned maximum. It is
Yes.
minimum side.
Yes.
It may be more.
Yes,
At
it
least
may be.
169 per day should be considered, at
Yes.
least.
Yes. So what is your submission?
Learned tribunal rightly held that 6,000 rupees is monthly.
No, his submission is that
It should be more than that.
if you can prove that it was more,
Yes.
then the more is to be taken into consideration. But if there is no evidence,
Evidence is
again,
there, Lordship. Evidence is there.
we'll continue.
Two
We'll continue at 2. Yes.
Just
Yeah, yes.
item number 14. Next item, Lordship.
Yes.
Our friends on the government side, I think they will take time.
Social welfare matter, social welfare now became 2 parts, providence and development part. Sit the under the government. And there is no standing council. That's why we have to look after this matter.
But our name not reflected in the cost written, unfortunately, file was not in my hand, Lordship. That's why I may be seeking some time to reconstruct the file.
You are for the appellant.
Yeah, I'm for a 2 and 3 respondent.
Lordship, on behalf of Dina, Lordship. I'm for respondent 1.
Mr. Gogoi, you are for
2, 3 and 4, Lordship.
respondent number.
Respondent number.
Who is for the appellant?
Dina, Lordship.
Heard Miss, what is her name?
D. Sharma.
D. Sharma, Learned Counsel, appearing on behalf of Mr. D. Nath, Learned Senior Government Counsel. Also Mr. S.K. Poddar, Learned Counsel for the respondent number 1, as well as Mr. T.R. Gogoi, Learned Government Advocate, appearing for respondent number 2, 3, and 4, who prays for an adjournment on the ground that due to bifurcation of the Social Welfare Department into 2 departments, this matter is to be handled by him. However, he does not have you don't have the file.
Has to be reconstructed.
His brief has to be reconstructed, and therefore he seeks some time for the same. The prayer is allowed. Let this matter be listed.
Next week, possible 23 or 21.
Hearing matter,
All pending matter. Lordship, it is a clash between two government departments. So I have a contractor, I have worked,
Lordship,
completed the
after
work.
2 weeks. After 2 weeks. Lordship.
As per Lordship. Then in July.
You suggested it. August first week,
Lordship.
fourth
Even
of,
28 Lordship if possible.
fourth of August.
Fourth.
Fourth,
Fourth of August.
fourth of August.
Lordship.
This second.
Our name of the GA Assam should be reflected.
Name of the government advocate Assam
Lordship.
shall be reflected by the registry. in the
Government advocate, they are the most probably shown as the plaintiffs here. Lordship. Appellants, sorry.
Yes. Cause list.
It is shown as the appellants here, Lordship, for the PWD. For PWD. They are the appellants here.
Department of PWD.
Departmental standing also. It may be confusing by the showing government advocate because both are the governments. Appellants are also government.
You are standing counsel
Not standing counsel also, I am government advocate.
and a government advocate shall also be shown as engaged counsel for the appellant. Appellant or respondent number 2, 3 and 4.
Appellant is the department, Lordship, PWD department.
Record some.
It is shown as the standing council social welfare department. They are the respondents here.
Where is the memo of appeal? You are appearing for Mr. Gogoi, you are appearing for
2, 3 and 4, Lordship.
Social Welfare Department, na?
This is the Women and Child Development Department. Nowadays, Lordship. Earlier it was under the
Hey,
Social Welfare
Ye
Department.
likh le, Amita, last line, last. As engaged counsel for respondent number 2, 3 and 4. Henceforth, list accordingly.
Of license.
For reasons mentioned in this judgment, this criminal petition is dismissed.
May I please to Lordship, I would like to mention item 3. Kindly adjourn this matter for the day. My senior counsel cannot reach today.
What is your name?
Jet Hussain on behalf of H.R. Choudhury.
What is your name?
Jet Hussain.
J.
Jet.
Z. Or
Yep.
Mr. Z. Hussain, appearing on behalf of Mr. H.R. Chaudhary,
My lord, fix this matter.
learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel. Also, Mr. K.K. Parashar, learned additional public prosecutor, who does not raise any objection. This prayer is accordingly allowed. Let this matter be listed
Tomorrow, my lord.
day after tomorrow. 7.
Highly obliged, my lord.
16 July.
16 July.
Mr. Talukdar, how long will you take?
Half an hour.
Okay, then we'll take one small matter, Miss Bora and Miss Bhattacharya. We'll take 5 minutes for 5 minutes. Have you taken instruction?
Yes, Lordship. Lordship, his already business is collapsed, Your Lordship, after COVID-19. So, Lordship, with due respect, Your Lordship, I'm not able to pay 15 lakhs, but yes, Your Lordship, he hardly can manage 5 lakhs rupees at this time, Your Lordship.
Lordship, after COVID, Lordship, we have given this Lordship evidence before the court that he has 4 night pass, Lordship.
Lordship,
Use
that is
AC
there,
for
Your Lordship, I
implementation.
can.
This is only for
Yes,
the
yes,
purpose
and
of stay.
Yes,
We are not allowing, saying that he has to pay only 5.
50% Lordship, that may be.
No,
That is-
only till the date of hearing, you take in the meanwhile. In the meanwhile, considering the pendency of this,
After deposit, they may file on affidavit that they have already deposited the amount. Otherwise, it will.
Okay.
After depositing.
then it has to be again listed.
Yes, thereafter it will be stayed. After
Wallet date
depositing.
has been given.
After depositing, they
No,
file an affidavit Lordship, stating that they have deposited.
Within 30 days, if they don't deposit, you go for execution. After the deposit of the aforesaid amount before the registry of this court.
Before the direct, no, not receive before the.
No,
Okay, Your Lordship.
yes.
Your Lordship, so far as monthly income is concerned, the learned tribunal discussed in detail, Your Lordship. Lordship, kindly-
Monthly?
Monthly income.
Oh, yes.
Lordship, kindly see page 22 of the memo of him. Internal page 10, paragraph 13 onwards. May I read, Lordship? The claimant claims that he was a day laborer and was earning rupees 6,000 per month. In support, he produced 2 income certificates from Gauhati Panchayat and circle officer. Page 22 of memo of the paragraph 13.
Para 13.
Lordship,
Para 13 is page
page 22.
24. Not 20. Internal page?
Internal page 10.
Internal page?
10. Lordship.
10. Yes, page 24. Yes.
Lordship,
Please.
got it?
Yes.
The claimant claims that he was a day laborer and was earning rupees 6,000 per month. In support, he produced 2 income certificates for Gauhati Panchayat and circle officer marked as Exhibit 10 and 11, respectively. Gauhati Panchayat certificate is not proper authority. Gauhati Panchayat is not the proper authority to issue income certificate, but at the same time, it is to be admitted that circle officer is the competent authority to issue the income certificate in the state of Assam. The circle officer certified that the claimant was having annual income of rupees 72,000 out of occupation of day labor. Since the income claimed by the claimant is as well as certified by the circle officer is not beyond ground reality, it is important also, which indicates daily income of rupees 200 and monthly income rupees 6,000. I have accepted the claim of the claimant that he being a day laborer used to earn 6,000 per month. The learned tribunal considered the ground reality. Has annual income in this case is accepted as 6,000, so. Then Lordship,
What ground reality?
ground reality, Lordship.
What is the meaning of ground reality?
Practically, Lordship. 200 per day, Lordship. It is on the lower side, Lordship. A day laborer.
Okay. But his submission is that Exhibit 11 was issued in the year 2017.
Lordship, that is there, but there will be some mistake. Typography will make a mistake. And Gauhati certificate is there. It is clearly mentioned, Lordship. Lordship, can you see Gauhati certificate, Exhibit 10? This is to certify that Mr. Muhammad Ashraf Ali Gorguya. Yes, you got it? So-and-so, permanent resident of village so-and-so. He was a day laborer of Dhanchera stone quarry, and he was having a monthly income rupees 6,000 per month. But due to revision so-and-so, the Gauhati certificate is there.
But what about the observations made by the tribunal that
Tribunal ground reality, practical aspect of the matter should be considered, Lordship. 200 per day, a day laborer is on the lower side, Lordship. In this regard, there is judgment of the Supreme Court. A visible vendor, says Sadiq's case, Lordship. Matter relates to incident of 2008, and there in present case, incident of 2014, Lordship. Lordship, can you see page 373, paragraph 8, Lordship? The appellant claimant, Lordship, got it?
yes.
The appellant claimant in his appeal further claimed that he had been earning rupees 10,000 per month by doing vegetable vending work. The High Court, however, considered the loss of income at rupees 3,500 per month, considering that the claimant did not produce any document to establish his loss of income. It is difficult for us to convince ourselves as to how a labor.
So without documents also some assessment.
Without document.
Okay.
6,500 taken in the year 2008, Lordship. In fact, the income considered is on the lower side.
No, you address that Exhibit 11 issue.
Lordship, that is mistake. I think there is a typographical mistake. Instead of
it goes against
was, it is written as is.
Okay.
And so as disability is concerned, Lordship,
Loss of earning capacity.
loss of earning capacity, Lordship. Loss of earning is the.
There is no discussion.
Lordship.
Functional, as regards functional disability, there is no discussion.
Yes, Lordship, that is there, Lordship, right? Lordship, kindly see again, paragraph 13. 12 lines from the bottom. No, Lordship, middle part, learned counsel for the claimant argued that due to sustaining 50% disability in relation to left lower limb, he has become 100% functional disabled as he cannot continue to render his occupation as day labor, for which he is entitled to 100% loss of income. But as per the disability certificate, the certificate has claimant sustained 50% permanent disability as per the assessment of disability by expert, and his other limbs are not affected. So I am reluctant to agree with the submission made by the learned counsel on behalf of the claimant. At the same time, claimant was a day labor which requires full physical involvement. I cannot treat his loss of income lower than the percentage of disability. Hence, this tribunal is of the considered opinion that it is just and reasonable to stick to the percentage of disability in regard to the loss of earning also. Hence, this tribunal finds it reasonable to hold that percentage of loss of earning is also 50%, which is the established percentage of permanent disabilities. To assess the loss of age, loss of income, age of the claimant is required. Claimant was so. And so far disability is concerned, Lordship, one specialist doctor that is there can issue disability certificate. One specialist doctor of a government hospital can issue disability certificate. Notification is there.
Where is the notification?
Notification is there. Number one. So the governor of Assam is pleased to notify the following medical authorities as competent authorities to issue disability certificate to the persons with disability. Number one, in case of singular disabilities, the specialist doctors working in government hospitals, namely primary health centers, community health center, and hospitals at subdivisional and district level, and medical college hospitals. The disability certificate was issued by the orthopedic doctor of SMCS, Silchar Medical College Hospital, this government hospital. It is mentioned in the judgment also, that notification was issued.
Okay. Anything else? Anything else?
Did the judgment, relevant portion of the judgment,
No, I have gone
so
through.
far disability is concerned.
Yes, the judgment also mentions about what you have just now stated.
Lawsuit that is there. Lawsuit, so far as my further submission is that the amount awarded by the tribunal is on the lower side.
There is no cross.
Loss of future prospect has not been considered. Future treatment has not been considered. He was under treatment as indoor patient for 73 days, Lawsuit. 73 days. Lawsuit, can you see? Several occasions he was admitted and discharged, Lawsuit. Lawsuit, kindly see at page 18. Of this memo appeal. Internal page 6, Lawsuit. 13 lines from the bottom, Lawsuit. The discharge certificate of SMCS marked as Exhibit 1 reveals that the claimant was admitted on the date of accident on 7/4/2014 and discharged on 16/5/2014. The 39 days. The PW2 medical officer being registered of orthopedic department reports that claimant was diagnosed as a case of type 3 compound fracture, both bone distal leg left with developing injury, serious injury, Lawsuit. Developing injury means severe injury.
What is the meaning of degloving injury?
It means serious, I found.
What serious? What is the nature? What it means? Degloving injury means, degloving means removal of skin.
Or death. Yes, yes.
It may not be serious.
Removing skin.
In some cases, it may be serious. It may not be serious in the. You have not filed any cross objection.
That is judgment of the Honorable Supreme Court as well as High Court, that without filing cross objection and cross appeal, amount awarded may be increased.
Yara?
So this is marked upset. Lordship can receive. Page 854, paragraph 14 onwards. Relevant 15, Lordship. In an application filed for compensation, the court is therefore required to ascertain the just compensation payable depending upon the evidence adduced by the parties. The court therefore can pass the award for compensation more than what has claimed by the
No,
claimant.
there is no dispute on this. It is an observation regarding the original application, not the appeal.
Here, I'm reading it.
Yes. Yes, please read.
That part it is there.
Read.
The court therefore can pass award for compensation more than what has been claimed by the claimant in the claim application. The court's duty being to award just compensation if the appellate court finds that the amount of compensation awarded by the tribunal is not just, it can enhance the same and award the just compensation.
Yes.
Even in appeal preferred by the owner or the insurer, even in the absence of any cross appeal or
that
cross
power is
objection
there.
by the claimants. In this regard, next one, Supreme Court's judgment, Lordship. I have marked it, Lordship. Page 677, paragraph 13. The tribunal has awarded 2,24,000 as against the same. The claimants have not filed any appeal. As against the award passed by the tribunal when the claimants have not filed any appeal, the question arises whether the income of the deceased could be increased and compensation could be enhanced. In terms of Section 168 of the Motor Vehicles Act, the courts tribunals are to pass awards determining the amount of compensation as to be fair and reasonable and accepted by the legal standards. The power of the courts in awarding reasonable compensation was emphasized by this court in so as against the award passed by the tribunal, even though the claimants have not filed any appeal, as it is obligatory on the part of the courts tribunals to award just and reasonable compensation, it is appropriate to increase the compensation.
Okay.
The
So in your case, for future medical treatment,
no
amount
amount has been given, and loss of marriage life, that is not considered.
What is
He
loss
was
of marriage?
below 20 years.
What is loss of marriage life?
Marriage prospectus.
But that plea has been, whether have you taken that plea?
Even we have not taken any plea, court should consider that. There are several judgments of the almost Supreme Court.
Okay, loss of marriage first.
I'm punishing it. Future treatment and marriage pursuit, I'm submitting judgments. So many judgments are there.
Okay.
So far as future treatment is concerned, and then also
What
the
future
loss of
what future treatment do you
future
require?
treatment, he was under the treatment for 73 days as indoor patient.
As indoor patient, you just now said that he was for 39 days only.
39 days one time. On
Okay.
different occasion, he was admitted.
No. Okay, total 70.
4 or 5 occasions he was admitted and discharged.
So he was admitted for 70.
See, I'm reading again.
No need to read.
70, it is mentioned also in the judgment, 73 days in the hospital.
I'm not disputing. I'm just
70, Lordship, and this is paragraph 12.
70. How many days? 70.
73 days in hospital.
So what is the basis that he will require future treatment? On what basis you are?
Is in every case, in the facts and circumstances, considering the facts and circumstances, court can award amount for future treatment.
No,
There are
whether he
facts-
requires future treatment or not, how the court will come to that conclusion?
Considering the entire facts and
What
circumstances.
entire facts and circumstances?
He was severely injured.
For
And-
which you have already taken treatment
Treatment was taken, but further treatment is required.
for the same ailment.
Yes, Lordship.
Oh, is there anything to indicate that you need future treatment?
He's not there, Lordship. But
Okay. Anything else? Right.
I'm on other heads is on the lower side also.
Okay. Heard Mr. KK. But
I have submitted different judgments also, that is there also.
learned counsel for the appellant. Also,
Regarding just commission, I want to
Rebut.
reply. Just commission means neither a windfall to the claimants or nor a penalty to the insurer. There is no medical evidence in support of them that any future treatment was required.
okay.
And Lordship, Lada Tribunal did not consider the exhibit 10 certificate issued by the Government Panchayat, considered the certificate issued by the circle officer. And as per the circle officer certificate, the claimant is doing earning after the accident, that is in the year 2017. Lordship. So there is no loss of earning.
Heard Mr. KK Bhattu, learned counsel for the appellant. Also heard Mr. M. Talukdar, learned counsel for the respondent. Have you received any compensation amount till now? You have already received.
No, 50% is 50%.
50% was
Okay.
what's
Okay. Hearing concluded, judgment reserved.
Lordship, I want to mention item number 30, Lordship.
Yes.
With me.
Item number 30.
Let me please stop.
Heard Mr. KK Bhattu, learned counsel for the appellant. Also heard Mr. Yes, what is your name?
AU Ahmed, Lordship.
AU Ahmed, learned counsel for the respondent. On request of learned counsel for the appellant, this matter is adjourned for the day. Let this matter be listed.
First, Lordship.
No. After 4 weeks, let it be there. If you want a fixed date, it will go to October. Let this matter be listed after 4 weeks on a date to be fixed by registry.
Lordship.
Lordship, in this case also, Lordship, we are challenging quantum of compensation. In this case, it is a injury case, case of amputation of right leg below knee. The disability certificate shows that it is a case of permanent disability to the extent of 70% in respect of the limb concerned. And medical evidence says that the doctor did not treat him. He only came to repose on the basis of one certificate, that is on the basis of record, lordship. But learned tribunal had taken the loss of earning capacity to the extent of 70% itself. So 70% is the loss of 70% is a permanent disability in respect of one particular limb. That cannot be the loss of earning capacity or functional disability to the entire body loss. Lordship may come to running page 17. Lordship, I am reading the relevant portion. Paragraph 13. Lordship.
Pagination is
Lordship.
page 17.
Running page, Lordship. Paragraph 13.
Yes.
The claimant claims that he was a businessman of vegetables and was earning rupees 15,000 per month. Hence, it is the claim of the claimant that he was associated with vegetable business, out of which he used to earn rupees 15,000 per month. To prove income, he marked an income certificate issued by Circle Officer as Exhibit 11. On perusal of the annual income of the claimant is found certified by the Circle Officer as rupees 1,80,000. Hence, the claim of the claimant is corroborated by the income certificate issued by the Circle Officer. Careful perusal of Exhibit 11 reveals that it was issued by Circle Officer Nilam Bazar on the basis of report of Land Revenue staff. It is also revealed that Exhibit 11 certifies the annual family income of the claimant for the year 2013 to 14. So it is the income of the family income, not the personal income of the claimant, lordship. We have challenged his income on the higher side also, lordship, in this appeal. None from the Circle Office has been examined to show the basis for assessment of income, nor has the defense got the opportunity to cross-examine the witness on Exhibit 11, where the defense in cross-examination of PW1 confronted him with suggestion that his monthly income is not 15,000. It was the duty of the claimant side to adduce evidence to prove the contents of Exhibit 11. As we know, a vegetable businessman constitutes an unorganized sector of economy, and there cannot be any stable income. In such case, we cannot rely upon Exhibit 11 as proof of income of the disease. Where we cannot rely on the income certificate, we are to fix a possible monthly stroke yearly income on the basis of ground reality to assess the aspect of loss of income. The accident took place in the year 2014, and in that year, we can very well guess the monthly income of the claimant as rupees 9,000. The learned advocate for the claimant argued that in relation to amputation of right leg below knee, the claimant has become 100% functionally disabled, as he cannot continue business, for which he is entitled to 100% loss of his income. But as per the disability certificate, the claimant sustained 70% permanent disability. As per the assessment of disability by expert, and his other limbs are not affected. So I am reluctant to agree with the submission made by the learned counsel on behalf of the claimant. Claimant may have difficulty in movement, but with the help of transportation to the place of business, he can conduct his business regularly. This tribunal is of the considered opinion that it is just and reasonable to stick to the percent of disability in regard to the loss of earning also. So this aspect lordship he had taken from his own, learned tribunal had taken from his own presumption lordship. Hence, this tribunal finds it reasonable to hold the percentage of loss of earning is also 70%, which is the established percentage of permanent disability. It is the established percentage of permanent disability as per certificate, but certificate is silent as regard functional disability, and evidence of doctors is also silent also. There is no evidence that his functional disability is also 70%. There is no evidence in the record also. To assess loss of income is of the claimant is required, and such this is lordship in this regular other competition is made. So lordship, lordship may come to lordship, lower court record is there, lordship, evidence of doctor is there. Lordship.
W.
Evidence of Dr. Lordship, Samim Ahmed Borgnia.
He deposed as
A PW2, medical officer as PW2.
yes.
Lordship, may I read, Lordship?
Yes.
On oath, I have been authorized by SOD Orthopedics to depose in this case. Exhibit 2 is the discharge certificate. On 29/11/2014, the patient, namely Tazal Ahmed, aged about 20 years, was admitted with diagnosis of crash injury, right foot, following alleged history of road traffic accident on 25/11/14. Patient underwent below knee amputation under SA, that is let's see, SA on 31/12/2014. Exhibit 2.1 is the signature of Dr. Parag Gogoi. At the time of discharge, physiotherapy was advised and to attend GMCAs for rehabilitation and to lordship, that is under SA means lordship, spinal anesthesia, lordship. Dr. Parag Gogoi. At the time of discharge, physiotherapy was advised and to attend GMCS for rehabilitation and to review in ortho. Exhibit 3, 2, 3, 4, 24 are the prescriptions and slips issued from SMCS. Exhibit 4.1 is the blood investigation report issued from SMCS. Exhibit 5.2, 5.2 are blood requisitions. Exhibit 8.2, 8.5 and 8.10 are the medical bills and cash memos issued from SMCS. Exhibit 9 is the disability certificate by number such and such, dated such and such, issued in the name of Tazal Ahmed, aged 20 years, certifying 70% permanent physical disability in relation to below knee amputation, right leg. So only one portion of the body is certified to have disablement to the extent of 70% lordship. Exhibit 9 was the signature of Dr. Sudipon De, Registered Orthopedics. The injury mentioned in the disability certificate and discharge certificate are same and is grievous in nature. In cross lordship, he said, I was posted in SMCS in the year 2017 in the post of Register of Orthopedics. During the period of treatment of the patient, I was a postgraduate student. I did not treat the patient and my signature is not available in Exhibit 2. This injury may also be caused due to fall of heavy object or workplace injury other than RTA. It is not a fact that the injury was not sustained by the patient due to RTA. The injury is not curable. There is no mention in the discharge certificate that the patient continued follow-up treatment. The patient cannot do his regular work as he underwent amputation of right leg below knee. It is not a fact that a patient can do his regular work. I did not issue the disability certificate, vide Exhibit 9. It is not a fact that a patient did not appear personally before the medical officer at the time of issuance of disability certificate. It is not a fact that medical norms were not followed to issue the disability certificate. As I have been authorized by SOD Orthopedics, I have appeared before the court and deposed on the basis of record. I have no personal knowledge regarding injury and treatment of the patient, Lordship. He neither treated the patient nor he has any personal knowledge about any disability, Lordship. And Lordship, there is only also disability certificate also there. So which clearly shows that must be there, Lordship, exhibit 9, Lordship.
No, what you want to submit? That the doctor did not produce any
He
evidence
did not.
regarding functional disability.
Yes,
That is the subject.
yes.
Okay.
And Lordship, disability certificate is there, exhibit 9, which says the disability is 7% in relation to impairment. Lordship, there will be there. Disabled 70%, permanent physical impairment in relation to right lower limb. So it is specifically written that only in respect of right lower limb, his disability is 70%. So disability in respect of particular limb does not constitute disability of the whole body, Lordship. That is our submission, Lordship. And the disability in respect of whole body will be in the lower side, Lordship. And coming to the deposition of the victim, in his evidence, he said, it is there in the written in Bengali language, Lordship, vernacular. Lordship, we put to the same.
15.
Evidence of claimant.
Yes.
It is in Bengali, Lordship, written there.
What you want to show?
Just I want to show that his business is still going on, Lordship. That is as per his deposition. In SIF, affidavit he has said like that, Amar Naam Mohammad Tajul Ahmed, Urope Tajul Ahmed. It is dear Lordship. Lordship has got that.
Yes.
Tajul Ahmed, Urope Tajul, Urope Kajal, Urope Tajal, Pita Mito Faizul Haq, Urope Faizul Haq, Boyok, আনুমানিক 23 বছর, শাকিন গ্রাম লোহারপাড়া বাহাদুরপুর, পোস্ট অফিস থানা নীলামবাজার, জেলা করিমগঞ্জ, আসাম, পেশাব পাইকারি সবজি ব্যবসা, ধর্ম ইসলাম জাতি. That is in his affidavit he has said that the time when he signed this affidavit, he was doing a paikari sabji ব্যবসা. That means wholesale vegetable business he was involved also. In later portion of his affidavit, he has said that I cannot work now. But this document shows that he was doing wholesale business of vegetable at the time of filing this affidavit. Now coming to Lordship, my appeal memo. Our contention is that, Lordship, in case of amputation of lower limb, Lordship, the functional disability as per EC Act, Lordship, is 50%. So at best, Lordship, tribunal should have taken that same at the extent of 50% in absence of any evidence that his functional disability is 70% or something else. The learned tribunal had accepted functional disability on the basis of what was written in the disability certificate.
Okay.
Lordship, as per EC Act, Lordship, in case of below knee amputation, functional disability is loss of earning capacity is assessed as 50%, Lordship.
As per the schedule.
Schedule.
Okay.
WC Act, Lordship. Schedule 1. And in this respect, Lordship, I want to rely on the decision of the Supreme Court in Rajkumar. That's Lordship, paragraph 16. Lordship had got paragraph 16. Lordship.
Yes.
The tribunal should not be a silent spectator when medical evidence is tendered in regard to the injuries and their effect, in particular the extent of permanent disability. Section 168 and 169 of the Act make it evident that the tribunal does not function as a neutral umpire as in a civil suit, but as an active explorer and seeker of truth who is required to hold an inquiry into the claim for determining just compensation. The tribunal should therefore take an active role to ascertain the true and correct position so that it can assess just compensation. While dealing with the personal injury cases, the tribunal should preferably equip itself with medical dictionary and a handbook for evaluation of permanent physical impairment. For example, manual of evaluation of permanent physical impairment for orthopedic surgeons, prepared by American Academy of Orthopedics Surgeon or its Indian equivalent or other authorized texts, for understanding the medical evidence and assessing the physical and functional disability. The tribunal may also keep in view the first schedule to the Workmen's Compensation Act 1923, which gives some indication about the extent of permanent disability in different types of injuries in the case of workmen. So my humble submission, the EC Act says that in case of below knee amputation, the functional disability or loss of earning capacity is considered to be 50%. So in absence of any evidence from the concerned doctor that it is a case of functional disability to the extent of 70%, it should be taken at the best at 50%.
Okay. So if the evidence is not there,
Yes.
so instead of making a guesswork,
Yes.
tribunal should have relied upon
Yes.
Schedule 1 of the one. That is your submission.
Yes.
Okay.
Other lordship, it is a case of accident of 2014 lordship. And monthly income was taken as rupees 9,000. That is in the higher side lordship in our submission lordship. And another submission lordship, future prospect is added in this case 40%. That is lordship. I am not objecting. That is future prospect is given 40% considering his age to be about 20 years. But interest is also given in the amount awarded in the head of future prospect. So in entire amount, interest was imposed. So my responsive submission or lordship is that interest should not be given in the amount awarded in the head of loss of future prospect lordship. And 7% interest is given. My submission is that is also in the higher side lordship. These are the main grounds.
Yes.
Lordship, so far disability is concerned, it has been duly proved, Lordship. Disability certificate was issued by the government doctor, specialist doctor, and that has been duly proved by another orthopedic doctor.
No. Functional disability to the
This disability has to be assessed by the tribunal,
tribunal. Yeah.
not the
No,
doctor.
his submission is while assessing functional disability,
Lordship.
when there was no evidence on record to arrive at a conclusion, tribunal ought to have relied upon Schedule 1 of the workmen compensation.
Sir.
That is his submission.
So here, the Lordship, there is no employer-employee relationship here. So we have filed claim petition under the MB Act, not EC Act. There is no master servant relationship here. So EC Act, or schedule of EC Act is not applicable. Recently, Lordship judge delivered judgment. In this case also I have, Lordship.
Era? Which para?
Lordship. Lordship, paragraph 15, Lordship. Paragraph 15, I have not marked actually. Paragraph 15, Lordship.
Yes.
Lordship, consider 70%, that is same, similar case, Lordship. 70% loss of money has been considered, 70% disability is there. And that is also right leg. Here also the right leg. Paragraph 19, Lordship say. Then Lordship, paragraph 22, Lordship.
No, okay, but
22, Lordship.
but he is relying on a judgment of apex court in the case of Rajkumar, where it was observed that where the evidence is not there, the court may also keep in view the first schedule. It is not that it is always mandatory to apply for first schedule. It may keep in view the first schedule of the Workmen Compensation Act while assessing the
Judgment, that last August, I submitted the judgment, I will submit the same.
okay.
And
Wow,
rely
wow.
on that the judgment, you Lordship passed the judgment. Supreme Court judgment, Lordship.
No.
While there is no relationship, employer and employee relationship, and claim is filed under the MB Act, so schedule of EC Act should not be applied.
No, it does not say that you apply for schedule. It says that you keep it in view as it gives some indication of the extent of functional disability.
No, sorry, Lordship, I could not take this judgment. It is very clear in that judgment that when claim petitions fell under the MB
Okay,
Act,
you submit it later on.
I will submit this.
Anything else? Anything else?
Their main contention is as regards loss of earning capacity. And so far as monthly income is concerned, I think they have no objection.
We have taken that count, Lordship, income is in the higher side, Lordship, 9,000 without proof. And whatever he had exhibited, Lordship, that was a family income, Lordship, not his personal one.
The family income is that is there, but there in that certificate that 1,80,000 has been mentioned. Yearly income. That means 15,000 per month.
Okay, okay. You,
And
sir.
so far as Lordship.
Yes.
So far as again I am referring to the so far as income is concerned, I mean, again, relying on the Said Sadiq's case. It's a vegetable vendor, and it is not expected that vegetable vendor can produce income certificate. So in the year 2008, the income was considered, vegetable considered as 6,500.
Okay. Heard.
And 2014, it should have been 9,000 or more. It's not in the higher side. Lordship, so far as future income, interest on future prospect is concerned, there is judgment of the almost Supreme Court.
Which judgment?
Is discussed in detail, Lordship. Interest should be given on future prospects also, Lordship.
Interest should be given. Which para?
Lordship. Mark, I have marked in paragraph 9. Only I'm reading out, Lordship.
Yes, please read.
A very relevant issue agitated by the insurance company is the illegality in awarding interest for future prospects, which in any event is an amount received in advance, normally inuring to the benefit of the claimants only in future. This is the only contention taken in the connected appeals also. We find absolutely no reason to accept this argument. Then, Lordship, paragraph 10, Lordship. We cannot but observe that there was nothing stopping the insurance company from settling the claim on a computation on receipt of intimation of the accident, especially since the determination of compensation for loss of dependency on death being occasioned in a motor vehicle accident can be determined as evident from the judicial precedents, at least provisionally. Then 11. In fact, it is due to the repudiation of or refusal to consider the claim that the claimants are driven to the tribunal. When the matter is pending before the tribunal or in appeal before the higher courts, the claimants are deprived of the compensation for future prospects. If they are paid in time, it could be utilized by the claimants, and on failure, the loss of dependency would force the claimants to source their livelihood from elsewhere. This is sought to be compensated at least minimally by award of interest, which oftener than ever is nominal also, since only simple interest is awarded. If the amounts were disbursed to the claimants on a rough calculation on intimation of the accident to the insurance company, subject to the award of tribunal, necessarily there would not have been any interest liability, at least to the extent of disbursement made. Hence, we reject the contention and direct the entire award amounts would be paid with interest at the rate of 9% from the date of the filing of claim till the date of disbursement.
Okay. Whether this case is reported anywhere? Have you checked?
Judgment, Lordship. Reportable judgment, Lordship. 2025 INSC 822.
Okay.
Lordship. And so far my understanding, Lordship, the whole concept of awarding compensation is based on future, Lordship. Loss of dependency in death cases, loss of dependency means loss of future dependency. Or in injury cases, loss of future income. Both relates to future. So if interest is granted on those two components, then why not on future prospect. All relates to future.
Yes.
The loss of immunity is calculated on the basis of future. The loss of income of the injured based on future. All are future. So why not on future prospect?
But the apex court in its judgment has not explained.
My understanding, all based on the whole concept of awarding compensation is based on future, not past.
Yes.
Lordship, my submission in this regard that the decision of the Honorable Gauhati High Court was lucid and it has given every reason
No,
so
but-
why it was
but-
given, not given in the amount.
But
which was
suppose
appropriate.
High Court says that it should not be given.
Yes, Lordship.
And apex court is saying that it has to be given.
Lordship, that is case to case fact whereas in this case, Lordship, so far my knowledge goes, Lordship, because due to the fact that it was not settled in time, for that reason, it might have
Yes.
been given, Lordship. But it is not a detailed and lucid judgment and there is no proper explanation of everything, Lordship. And in particular, that case, Lordship, the Honorable Supreme Court have
Reason
decided.
has been.
Yes. That was different, Lordship, my submission.
Lordship, my further submission is that the amount should be enhanced in view of the, although we have not filed any cross objection or cross appeal. I am again submitting the
Enhanced on what count?
Lordship
Against which
future
count?
treatment. It's a case of disability, 70% disability. So artificial limb is required. And in that judgment also, I have furnished the judgment, Lordship, your Lordship judgment. Here also 6 lakhs has been given for future prospect, future treatment. And again, loss of marriage prospect.
Okay.
Lordship, I am
This-
submitting some judgments. Here
No,
in this case, there is
Mr.
another Supreme Court judgment.
No, Mr. Talukdar. You are taking some new points which you have not taken in the memo of appeal. These are only oral submission.
Yeah, that is why I am submitting the Honorable Supreme Court High Court judgment that without filing cross appeal or cross objection,
Therefore, you
again I am submitting the same.
submit a written gist of your submission, argument. I am reserving it.
Filing cross appeal with the amount can be increased.
You submit a written gist of your argument.
Lordship. Here also, Lordship, yeah, there is another judgment of Supreme Court.
No,
That-
not in this manner. You submit a written gist of your argument.
Lordship.
When?
Within a week.
Give me date.
See.
Heard Mr. A.J. Sakya, learned counsel for the. You take back the judgments. Written gist of Logot.
Right.
Also heard Mr. M. Talukdar, learned counsel for the respondent. As well as Mr. What is your name? Yes, thus appearing for respondent. The respondent / owner of the offending. Though hearing is concluded, the learned counsel for the, will you let them file written gist? If you want, you may also file.
I have
Learned-
already submitted, Lordship.
Okay, yeah,
I
yes, the
will,
learned counsel for the respondent / claimant is requested to submit written gist of his submission on 30 July, list accordingly. It will be again listed on 30. list accordingly as part of matter. I'm taking a short break.
May it please your lords. Well, it's a very small matter, my lord. Matter relates to a judgment against the Workmen Compensation Act. Presently, it is Employees Compensation Act, my lord. We had the substantial question
Workman compensation. Employees compensation. Yes. Totally.
Impugned judgment starts from page 9, my lord, and operated part from 10, my lord. Before that, I like to place before the lordship the substantial question law framed by this court. Honorable Court, my dear lord, as you can see. This is what the driver, my lord, he died at the age of 29 years. And date of that, my lord, it is of the 2013, 23/2013, my lord. So may I read from page 10, my lord?
Yes.
Where is the original claim petition dated 9/12/2015, filed jointly by the petitioners, Nasima Khatun, wife of late Harali, Johura Begum, the second wife of late Harali, and 3 Hafida Khatun, minor daughter, represented by mother, petition number 1, daughter of late so-and-so, Rakibul Islam, minor son, represented by mother, the petitioner number 1, son of late Haraz Ali, Hamid Ali, son of late, so alias Muhammad Hanif, father of late Haraz Ali, that is the driver, 6 Fatima Begum, mother. Though the appointed advocate seeking an award under provisions of the Workmen Compensation Act 1923 on account of death of the husband, father, son, so and so forth. The case of the claimants in brief is that their husband, father, son, this is Haraz Ali, aged 29 years, was employed as driver by OP number 1 in his vehicle number so and so with a monthly salary of rupees 12,000. That on 23/6/2018 at about 9 a.m. while so-and-so was performing his duty of driver of the vehicle, which was proceeding from Kolkata towards Gauhati with passenger, the vehicle met with an accident in front of the Sharbuk Navodaya school at Sharbuk under Sharbuk police station. As a result of the accident, the petitioner's husband, father, son, Haraz Ali sustained grievous injuries, and immediately he was shifted to Hayat Hospital, Gauhati for treatment. But the injured patient could not survive. He succumbed to his injuries and died on 26/3/2023 on the way while he was brought back from Gauhati. The information of the accident and the subsequent death, which caused to the accident of the claimant's petitioner husband, father, son, so and so, was reported in Sharbuk police station. The police investigated the accident and registered a case, while Sharbuk PS case number so and so. The post-mortem examination of the deceased Haraz Ali was performed at the Fakhruddin Ali Ahmad Medical College Hospital, Barpeta. On receipt of the claim petition, the case was registered and notice was served upon the opposite parties for filing the written statement, objection if any.
number one, that is Rafiqul Haq, owner of the vehicle Malur, while submitting his written statement, admitted inter alia that the claimant's petition's husband, father, son, so and so was appointed by him as the driver of the vehicle number so and so. He also admitted there is cause of action for the claim. In the written statement, Ofi admitted the fact that he used to pay the driver late Hazali rupees 8,000 per month. In his written statement, Ofi number one also added that the above mentioned vehicle was duly insured with the Oriental Insurance Company Limited by policy number so and so, having validity up to midnight number and on 12/5/2014. That is much after the death of this. In his written statement, Ofi Insurance Company denies the contents of the claim petition. It denies the content of the claim petition. It denies the employment of deceased driver Harazali as appointed by the Ofi number one his vehicle. It denies the husband, father, son of the claimant died in the course of his employment. That is normal. That is to be done with the deal. In the written statement of the insurance company also denies the age of the deceased and also monthly salary as claimed by the claimants. The Ofi Insurance Company as a whole denies the contention of the entire claim petition and refuses to pay the compensation. Then, my lord, in course of hearing the claim petition, number 1 and 2 examine herself as PW1, 2, and the 2 local governors at DWs. The claimants petitioners in their evidence on affidavit shown before the public Borfeta 9/12/2012, and again in the claim petition number 1, Nasima Khatun herself, and on behalf of the other claimants in her evidence on affidavit shown before Notary Public Borpeta, dated 27/6/2018, stated that their husband, father, son, Redali, was a driver of the vehicle number so and so, on 23/6/2013 at about 9 a.m., while Haridali was performing his duty of driver of the vehicle, which was proceeding from Kolkata towards Gauhati, the vehicle met with an accident at Sarbuk in front of Navargodha School. The police under the jurisdictions of Sarbuk Police Station. As a result of the accident, the claimant, petitioner's husband, father, son, sustained grievous injuries and immediately he was shifted to Hayat Hospital, Gauhati for treatment. But Harizali could not survive. He succumbed to his injuries and died on 26/6/2013 on the way while he was brought back from Gauhati. The claimant's petitioner stated that the case of the accident and his subsequent death was reported in Sarbuk Police Station, registered a case number so. The postmortem examination of the deceased Harazali was performed at FA Medical College Hospital, Borpeta. The claimant petitioner exhibited the following documents in support of the claim. Exhibit 1, police report. Exhibit 2, certificate of completion of postmortem report. Exhibit 3, death certificate. Exhibit 4, employee salary certificate. Exhibit 5, certified copy of FIR, and then certified copy of seizure list. Exhibit 7, certified copy of MBI report. Exhibit 8, certified copy of FIR. Exhibit 9, copy of the driving license. Exhibit 10, postmortem report. Exhibit 11, certified copy of unnatural case numbers 10/13. The claimants petitioners 1 and 2 and the DWs were duly cross-examined by the learned counsel of Ofi Insurance Company. During cross-examination, the claimant petitioner PW once stated that she got married with Hajar Ali the 14/15 years ago. Johra Khatun, the second wife of the deceased Hajar Ali, also married 8 years ago. Further, she stated that she was 12 years old at the time of her death, and the husband's age was 17 years. On the cross, she stated that the second wife, Johra, got remarried with another person and presently resides with her present husband at Jogi Gufa. On cross, she stated that she has not submitted before the court any age proof document of her children. Further, she stated that she has not produced any evidentiary document as wife of this is Hajar Ali. On cross-examination, she denies that she has not got remarried with other person, so she is not entitled to compensation. Now, on cross, she denies that she has got remarried with other person, so she is not. On cross, she denies that the deceased Hajar Ali had no siblings. While cross, she denies that her husband not died in a motor accident but died at home. During cross-examination, claimant's petitioner PW2 stated that presently she resides at father's home at Nastara in the Bongaigaon district. On cross, she confessed that after the death of her husband Hajar Ali, she got remarried with Anwar Hussain, and she has got talaq with him. These are elements of my life. On cross, she stated that her present age is 22 years and her husband died 5.5 years ago in motor accident. While cross, she stated that she got married with Hajar Ali 3 years ago before his death. On cross, she stated that she does not live in her husband's home, but they live together, the first wife, her children, and the parents of Hajar Ali. The two local governors appeared in the court as DWs, and they were duly cross-examined by the learned counsel of the insurance company. During cross-examination, Muhammad Ainuddin DW once stated that he knows Hajar Ali, who was a resident of Karaivili village. He died in motor accident about 5 years ago. On cross, stated that presently his parents, 2 children and a wife live in his home, and the second wife left his home after his death. While cross, he stated that he does not know about the second wife of Hajar Ali, where she resides. On cross, he stated that at present the first wife of the deceased Hajar Ali, their 2 children and the parents live together. During cross examination, DW2 Noor Muhammad stated that he knows Johra Khatun, but father's name is Abu Bakr Siddiq, who is his co-villager. On cross, he stated that he does not know whether Johra Khatun resides along with her father or not. On cross, he further stated that he is not aware about her number of children. The Office Insurance Company did not lead any evidence, and so whatever the evidence adduced by the claimants remained unreverted. After closure of the evidence, the case was posted for argument in the learned counsel for both sides. Both claimants in the Office Insurance Company advanced their relevant arguments. I have heard the argument advanced by the counsel for the claimants. In his argument, he asserted that from the written statement and the employment of salary certificate adduced by OFI 1, the evidence adduced by the claimants 1 and 2 herself, it should be themselves, the police report of Sarbuk Police Station and a postmortem report certified by the Associate Professor Department of Forensic Medicine, FAA Medical College Hospital, Barpeta, which is duly countersigned by Professor and Head of the Department of Forensic Medicine, FAA Medical College Hospital, Barpeta, at Exhibit 10. It is proved beyond reasonable doubt that the deceased Haidali was a workman as driver employed by OP number 1 and died in course of an arising out of the employment under OP number 1. So the claimants are entitled to compensation under the provisions of the Workmen Compensation Act 1923 as amended. I have heard the argument put forward by the learned counsel of the Office of Insurance. He raised some minor discrepancies at the time, but in filing the claim petition, age of deceased, Haradali and his employment and salary, and dispute in regard to the accident involving the vehicle, as well as the coverage of the insurance policy in relevant crime and accident. I have perused the case record and found that the OP number 1 admitted the fact of employment of the deceased Haradali appointed the driver in his vehicle with a monthly salary of rupees 12,000 per month, inclusive of daily allowances. The written statement adduced by OP number 1 admitted the fact of relation between the employer Rafiqul Mandal and the employee Haradali, this owner and the deceased minor, owner of the vehicle. The evidence adduced for the claimants as PW1 has proved that deceased Haradali was an workman of the vehicle owned by OP Rafiqul Mandal. The police report Exhibit 1 proves that the deceased Haradali was a workman of the vehicle owned by OP number 1 Rafiq Mandal. So the court comes to the decision to meet the end of justice, and Haradali was a workman as driver under the OP number 1. The claimants petitioners have failed to furnish any salary certificate in support of their claim for monthly salary, but considering the minimum rates of wage fixed by the Assam government and also considering the rates of wages of such skilled motor transport work at the time of the accident, that of Haradali, I am of considered opinion to accept his monthly salary of his 5,500. And this is the question here before the Honorable Court, my lord. As regards the age of the deceased Haradali, the claimants have failed to furnish any school certificate, past certificate as documentary evidence in support of his age, but they have produced the driving license of the deceased Haradali as Exhibit 9 issued by DTO Bangaigaon, wherein the DOB of Haradali is dated to be 14 to 1984. That is the date of death, birth, my lord. So in the absence of any such birth certificate, school certificate, his DL is accepted age of the proof of document and the age of the deceased Haradali on 26/3/2013 at the material time of his accident, the accidental death is determined as 29 years. From the police report, employee statement, claimant's evidence, doctor's evidence, and other documentary evidence adduced during proceedings, it is established that Haradali died in the course and arising out of the employment under OP number 1 The claimants are therefore entitled to compensation as per provisions under the Workmen's Compensation Act as amended. Now, taking into account the monthly salary of Haridali to be as rupees 5,500, his age at the time of accidental death was 29 years, and so the compensation payable to the claimants is computed as rupees 12. In this way, the court calculated his monthly salary, taking it as 5,500, whereas as for the certificate given by the owner of the vehicle, it was 12,000 admitted, and that document was exhibited at Exhibit 4 in the record, my lord. And the owner of the vehicle was also examined by the court, my lord, as PW1. So
Who was examined as
that is the vehicle owner, man.
Owner has been examined.
He is deposed for the court regarding the certificate.
Who exhibited Exhibit 4?
Exhibit the claimant side, my lord.
The owner exhibited.
Claimant side produced it before the court and owner was examined, my lord.
No, who exhibited Exhibit 4?
Exhibit 4.
PW1. So, yes, Mr. Datta. Yes, you have anything else to submit?
My lord.
Anything else to submit?
Please have it. Regarding the certificate, my lord, his salary as court, the honorable court has taken, the commissioner has taken is to 5,500, my lord, against the admitted position that he was being paid at the rate of rupees 12,000 as deposed by the owner of the vehicle, my lord. So our question before your submission before your lawsuit, my lord, that is, this is very much perverse. The fixing of the rupees salary as rupees 5,500 is perverse, arbitrary, and without evidence, especially when both oral and documentary evidence prove the higher wages. Such finding deserves to be set aside. The principle of evaluation. Then, under Section 4 of the presently it is the Employees Compensation Act, my lord. If you take it, your lawsuit, Section 4 of the Act, my lord. Amount of compensation subject to the provisions of the Act, the amount of compensation shall be as follows. Where the death results from injury, an amount equal to the 50% of the monthly wages of the deceased employees multiplied by the relevant factors. An amount of 1,20,000, whichever is more. Therefore, I ought to brought your lordship attention. Section 4A, my lord. The compensation to be paid when due and penalty for default. The compensation under Section 4 shall be paid as soon as it falls due. In case where the employer does not accept the liability for compensation to the extent claimed, he shall be bound to make provisional payment based on the extent of liability which he accepts. And as such payment shall be deposited with the commissioner or made to the employee as the case may be, without prejudice to the right of the employee to make further claim. So, my lord, here in the instant case, as I have brought your lordship attention, it is as admitted by the owner of the vehicle, he was paying rupees 12,000 per month. And he also adduced certificate. Given the certificate, he was examined by the court, and the arbitrarily learned commissioner fixed it at rupees 5,500. This is very much perverse, my lord. So therefore, the appellant prays that my lord, this should be enhanced to rupees 12,000. The salary and the matter to be calculated in this way.
What this 4,000 is there at page 13 of the judgment.
My lord,
Come to page 13 of the judgment. Page number 5 of the
Yes.
judgment. 50% of 5,500 into the factor, that is 209.92 plus rupees 4,000. What this 4,000 is for? Yes, Mr. Datto.
Your lordship, I believe it is as per the provision of the employees compensation.
Yes, which provision?
Your lordship, that I will have to look.
That 4,000 is added for what? Yes, Mr. Rajbur Bhaiya. What this 4,000 is for in the
I could not follow, my lord. He calculated it is 5,500 and now he has put it to 4,000.
no 5,500 into 209.92. That is the factor. Plus rupees 4,000.
This 4,000 I could not understand, ma'am.
That I have not understood. Okay, Mr. Datta, what is your submission? This is a perverse judgment.
Yes, your lordship, but with all due respect to my senior friend, lordship, the witness was not examined to prove this document, salary certificate.
Therefore, I was questioning who exhibited this exhibit 4.
The claimant exhibited.
But the owner admitted it in his written statement.
Yes, lordship, but he was not
Owner
examined.
admitted, my lord.
If he was not examined, we could not cross-examine to rebut the evidence.
But
Cross-examination has to be done by the insurance company, my lord. It is not our obligation.
But he has to be examined
you
first.
could have cross-examined the owner and the
Insurance company.
claimant who.
But as your lordship, as per the written statement, he admitted that he is to pay 12,000, inclusive of.
No, but
allowance.
in the impugned judgment, the tribunal, the commissioner observes that the claimant have failed to furnish any salary certificate.
Yes, your lordship. That observation.
That is a perverse error.
That is wrong. But he ought to have been examined, the issuer of the document.
Heard, Mr. M.H. Rajbur Bhuya, learned counsel for the appellant. Also heard Mr. S. Datta, learned counsel for the respondent. Respondent number 1 / insurance company. You have anything else to submit?
Yes.
This appeal under section 30 of the workman compensation. Have you received any compensation?
No. This is not it.
That I don't have any idea. I will have to inquire.
Compensation Act 19. impugning the judgment and award dated 8/10/2020 passed by the learned commissioner, workmen compensation, Borpeta in WC case number 328/2015, whereby the present appellants were awarded compensation amount of rupees 5,81,280 only on account of death of the husband of the claimant appellant number 1, namely late Harez Ali, in a vehicular accident during the course of his employment under the respondent number 2.
Respondent number 1, matter of Kulmanda.
Now, in this appeal, respondent number 2 of this appeal, within bracket, opposite party number 1 before the Commissioner Employees Compensation. The next para, the facts relevant for consideration of this appeal, in brief, are that the husband of the present appellant number 1, namely deceased Harez Ali, was employed as a driver by the present respondent number 2, namely Rafiqul Mandal, to drive his vehicle bearing registration number AS15C3135 within bracket Tata Cruiser bracket close at a monthly salary of rupees 12,000. Stop. It is stop on 23/6/2013 at about 9 a.m. when during the course of his employment, late Harez Ali was driving the aforesaid vehicle and proceeding from Kolgosia towards Gauhati. The said vehicle met with an accident in front of Sorbog Navodaya School at Sorbog under Sorbog Police Station. Stop. As a result of this said accident, the husband of the appellant number 1 sustained grievous injury and he was immediately shifted to Hayat Hospital at Gauhati for treatment. Stop. However, said Harez Ali succumbed to his injuries on 26/3/2013. It is pertinent to mention herein that 2013, stop. No. Accordingly, the present appellants approached the Commissioner Workmen's Compensation Barpeta by filing an application under the provisions of Employees Compensation Act 1923, seeking compensation for death of R.S. Ali in course of his employment as a driver of opposite party number 1. Stop. Stop. The driver of the vehicle, namely Rafiqul Mandal,
Owner of the vehicle.
the owner of the vehicle, namely Rafiqul Mandal within bracket opposite party number 1, submitted written statement in the aforesaid proceeding and admitted the fact that the husband of the appellant number 1, namely Harij Ali, was appointed as a driver by him to drive his vehicle bearing registration number AS15C 3135 Tata Cruiser, and also admitted where is the WS?
My lord,
WS of, you have annexed the WS of the owner?
no, I have not submitted it in the LCR is there.
No. Good. Yes, Chetri, you find out WS of the owner. Jalika. Admitted that he used to pay a salary of rupees dash UP बाद में fill up, per month to the deceased Haris Ali. It was also contended that the offending vehicle was insured with the respondent number 1, present respondent number 1, that is Oriental Insurance Company, and the validity of insurance policy was up to the midnight of
Insurance.
12/5/2014. Stop. In support of their contention, the present appellant number 1 examined herself as PW1 and also exhibited 11 documents which were exhibited as exhibit 11 documents as exhibit 1 to exhibit 11.
Yes, we can. সেটা দরকার নেই।
The owner of the offending vehicle, you got it,
Yes, ma'am.
WS by,
Yes, WS and the exhibit
no,
four,
exhibit is there, WS I want,
WS is sort of.
okay. In WS, he admitted 8,000 only. But exhibit is of 12,000.
12,000. And his deposition also, my lord, it is 12,000.
His deposition is,
Because typing, maybe it is because of the typing mistake, because it was drafted by the.
no, very, he has not deposed.
He deposition, yes, his deposition is also.
Deposition is there. वो जो blank लिखा था ना, dash rupees 8,000. What is the last line? The insurance company and the owner of the offending vehicle did not adduce any evidence in again in their defense. Ultimately, the commissioner employs compensation Borpeta by judgment which has been impugned in this appeal awarded the amount of compensation as already described in foregoing paragraphs of this judgment to the appellants. Stop. On filing of this appeal, at the time of admitting it, a coordinate bench of this court by its order dated 5/4/2021 formulated following substantial question of law. Number one, whether the learned commissioner acted lawfully and rightly in fixing the monthly salary of the deceased driver at 5,500, whereas as per the evidence on record / salary certificate, the income of the deceased was 12,000. Stop. Learned Mr. M.H. Raj Bhuya, the learned counsel for the appellant, submits that though the claimant, while deposing as PW1, exhibited the salary certificate issued by the owner of the offending vehicle as Exhibit 4. However, in the impugned judgment, at page 5 of the same, it was observed by the commissioner employs compensation Borpeta that the claimants / petitioners have failed to furnish any salary certificate in support of their claim for monthly salary. Stop. Learned counsel for the appellant submits that the aforesaid observation made by the commissioner, employees compensation Borpeta in the impugned judgment is a perverse observation, as apparently the salary certificate was exhibited as Exhibit 4 by the claimants within bracket PW1. He further submits that in his written statement, submitted by the owner of the offending vehicle before the before the commissioner, employees compensation Borpeta in WC case number 328/2015, it has been categorically stated by the owner that he used to pay a monthly wage of rupees 8,000 to the deceased driver Haraj Ali. Learned counsel for the appellant further submits that mention of rupees 8,000 instead of rupees 12,000 in the written statement might be due to some typographical mistake, as the Exhibit 4, that is the salary certificate, which was also issued by the owner of the offending vehicle, categorically mentions that the salary of the deceased at the time of his death was 12,000 per month. Stop. He therefore submits that since perversity in the judgment of the Commissioner Employees Compensation Borpeta, while assessing the monthly income of the deceased driver, is writ large on the face of the is apparent from the judgment itself, same is liable to be modified by taking the modified and the compensation to be granted to be awarded to the appellants should be reassessed after taking the monthly income of the deceased Haraj Ali at rupees 12,000. So on the other hand, learned Mr. S. Datta, the learned counsel for the insurance company, has submitted that though there appears to be a apparent erroneous observation made by the Commissioner Employees Compensation Borpeta in the impugned judgment that no salary certificate was produced by the claimants, as same was exhibited as Exhibit 4 by the PW1, however, he submits that the present respondent number, your respondent number? Respondent number 1, that is the insurance company, was deprived of opportunity of cross-examining the owner, as he was never examined by the claimant, and as such, the Exhibit 4 should not be taken into consideration. He further submits that Exhibit 4 was issued by the owner of the offending vehicle, and as such, to prove the said document, he ought to have been examined as a witness by the claimants. Anything else?
The first page of the impugned judgment,
Yes.
OP number 1 admitted that it was 8,000 pounds, the monthly salary.
He further submits that in the written statement, the owner of the vehicle, owner of the offending vehicle, had admitted the monthly salary of the deceased to be only 8,000 and not 12,000. And as such, the Exhibit 4 may not be taken into consideration. Stop. I have considered the submissions made by learned counsel for both sides. And I have gone through the materials available on record. I have also gone through the original records of WC case number 328/2015, which was requisition from the Office of Commissioner, Workmen's Compensation, Barpeta, in connection with the instant appeal. Stop. Monday, I will deliver the judgment on next Monday. Heard Mr. Rajbar Bhuya and list this matter for delivery of judgment on 20 July.
Right.
Wait, please, Your Lordship.
Yes.
The background of the case is this, my lord. Appellant's land were taken by the government for construction of railway line. So, my lord, against that compensation fixed by the district commissioner, my lord, he filed objection under section 18 of the 1889 Acts of Land Acquisition Act at that time. And also under
Land
section
Acquisition Act.
12.
1894. And whether new act is also
Matlab, new act, that entire exercise has been done under Act 1889 Act, madam.
1894.
1894, yes.
Yes. Okay. Your land was acquired.
My lord, by the collector, my lord, as a representative of the government. So, my lord, I accept this award, my lord, but with protest petition before the Deputy Commissioner under Section 18. Section 18 of the said 1894 Act and 64 Act, my lord, Assam Land Requisition and Acquisition Act. My lord. So, my lord, that petition was referred to the district judge, my lord, Bongaigaon. And ultimately, Honorable District Judge, my lord, passed the impugned judgment. Thereby, my lord, value of the land is increased up to 6 lakhs per bigha. But thing is this, my lord, in my protest petition, I have other grievances also. Those grievances is not addressed at all. So regarding increase of the land, my lord, that has been addressed. But now your lordship would be pleased to turn to page 11 of my memorandum of appeal, my lord. That is the petition, my lord. Page 11, my lord, an application under Section 12 of the Assam Land Requisition and Acquisition Act 1964 and under Section 18 of the Land Acquisition Act 1894 to refer the matter to the reference court. So and so, my lord. Now your lordship would be pleased to see para 2 at page 12.
Yes.
Here I allege that the petitioner is residing over said plot of land more than 40 years back along with his family members by constructing his dwelling house. More so, there is a big garden consisting of number of valuable food-bearing trees along with other valuable trees stand over the vacant portion of the said plot of land, which includes trees like kathal, am, narikal, jam, gamari, zia, sangal, simulu, sagua, mousumi, khejur, tamul, etc. In addition to that, said trees are number bamboo bush also located over the said plot of land. Similarly, another para 3, my lord, the government has acquired a portion of the land measuring 1 bigha 1 katha 5 lesa. But my grievance is this: I have got land measuring 4 bigha 2 katha 7 lesa. So when some portion is taken away, my entire plot of land became unusable.
How? Why?
Because, my lord, it is taken for the purpose of railway track. And railway track is constructed about 3 meters high. When it is up by 3 meters, entire land, my lord, inundated by rainwaters. So ultimately, my lord, that land become unfit for cultivation as well as for dwelling houses. So, my lord, when some portion is taken away, 1 bigha, other portion become unusable. So, my lord, your lordship would be pleased to see para 4. I have detailed grievance, my lord, that the acquiring the said plot of land measuring 1 bigha, 1 katha 5 lesa, the entire plot of land of the petitioner measuring 4 bigha 2 katha 7 lesa under Sheikh Dagan Patta has been divided into 2 parts and virtually became unusable because of the fact that portion of the land, whatever left out after acquisition is in such a shape that same shall not be suitable for purpose of construction or erection of dwelling houses of the petitioner. In the context, it is pertinent to mention here that since the railway line shall be constructed and passes through the middle portion of the entire land of the petitioner, and the height of the railway track shall be more than 3 meters, so the remaining land of the petitioner shall be submerged with rainwater during rainy season and shall be unusable usable for human living by constructing dwelling house. So the petitioner is entitled to a heavy compensation for damaging and destroying the entire plot of land. So my lord, my grievance is this, not that for my remaining portion of land, my lord, for my remaining portion of land, that is about 3 biga 1 katha 2 lesa, I am not claiming that I will be paid equal value, my lord. For remaining 3 biga 1 katha 2 lesa, my lord, I am not claiming that supposing 6 lakhs per biga have been compensated for acquired land. But I am claiming that as my land has been damaged, my lord, for this 3 biga, some adequate compensation is to be given by the railway authority. In the context, it is pertinent to mention here that Section 23 of the Land Acquisition Act 1894 has provided that in determining and awarding the compensation, the learned collector ought to have considered the points as enumerated therein. But here in this case, learned collector has passed the award without considering all those points as stipulated under Section 23 of the Land Acquisition Act. In its real perspective, and as such the award so passed is totally unjustified and thereby causes huge financial loss to the petitioner. Page 14, my lord. Claim of the petitioner at all, without applying his judicial mind, has arbitrarily fixed the value of the land at rupees 1,20,000. My lord, that 1,20,000 has been increased by the Honorable Court below, my lord, whereas the present market value 6 lakhs. That apart, collector also failed to apply judicial mind in assessing the valuation of the houses and structures and ziraat of the petitioner which stands over the acquired land, and assess total quantum of compensation at rupees 6,60,000. Being agreed, my lord, ground has been given. What I have stated, my lord, these are the grounds. Now your lordship would be pleased to see the order of the learned district judge, my lord. Before that, my lord, I want to point out to page 26, my lord. That is the assessment of the land, how it is done by the commission, by the district collector. Page 26. Para 3, my lord. That the compensation awarded to the petitioner under section 11 of the Act is as follows. Land value 1,50,000, structure 2,57,868, ziraat 58,549. Ultimately, it is calculated, my lord, solatium is given 30% and 12 additional compensation. It comes to 6,62,312. Now, my lord, your lordship would be released to see the impugned judgment, my lord. Similar fact has been discussed, and lastly, my lord,
Where is the impugned judgment page number?
district judge, my lord, finding of the learned district judge, my lord. My lord, here, page 33, page 34, my lord. Petitioner side adduced, para 7. Petitioner side adduced evidence of 3 PWs who have duly cross-examined by the other side. Opposite party's side did not adduce any evidence. After discussing evidence, my lord, your lordship will turn to page 37. Here is the finding. Page 37, para 13.
Yes.
My lord, para 13. From the above discussion, it appears that valuation of the land at the time of acquisition should not be less than 6 lakh per biga, being the average valuation of land of the locality. It is seen that land collector compensated the value of the land at rupees 1,50,000 at the rate of 1,20,000 per biga for the land measuring 1 biga, 1 katha 5 lesa from structure 2,57,000 and odd for Jirat 58 and odd with solatium 30% totaling 1,39,000 odd 59,900. Additional compensation rupees 6 lakhs totaling rupees 6 lakh 62,000 watt. It observed that district collector failed to assess the valuation land at the time of acquisition per biga. Accordingly, the valuation of the land at the time of acquisition enhanced from rupees 1 lakh watt to rupees 6 lakh per biga. And the petitioner is entitled to get valuation of acquired land. So, my lord, solatium, etc., that has been kept intact, my lord. And the interest has been given at 6% per annum. So, my lord, my humble submission before your lordship regarding interest, my lord, rate of interest, I don't hesitate, my lord. That is all right, my lord, 6%. But my humble submission before your lordship, the section 23 of the act is not complied with by the learned session judgment.
What has not been complied with?
My lord. Section 23. Yes, the section will and acquisition act my lord, section 23 Land Acquisition Act 1894.
Yes, what has not been complied with?
My lord, your lordship would see. In determining the amount of compensation to be awarded for the land acquired under this act, the court shall take into consideration first the market value of the land at the date of publication of the notification under section 4 of subsection 1.
That has been taken care of.
Secondly, my lord.
That was taken care of.
My lord, that is taken care of. Next, my lord. Secondly, the damage sustained by the person interested by reason of taking of any standing crops, trees, which may be on the land at the time of collectors taking possession thereof. Thirdly, the damage, if any, sustained by the person. Third one, my lord. The damage, if any, sustained by the person interested at the time of collectors taking possession of the land by reason of severing such land from his other land. So, my lord, this point is.
Which one?
Thirdly, my lord. Thirdly, the damage, if any, sustained by the person interested at the time of collectors taking possession of the land by reason of severing such land from his other land. That, my lord, that is my grievance in the petition I have read out before your lordship.
How this damage will be
My lord,
assessed?
my land, some portion has been taken away and other portion is damaged. So in my petition specifically, I said that additional compensation of at least 2 lakhs rupees may be given.
No, how it is to be quantified?
My lord,
How it will be assessed?
my lord, your lordship, that is a fact. That is a fact that total land was 4 biga, some lesser, my lord. So out of 4 biga, my lord, 1 biga has been taken away. 4 biga, 2 kata, 7 lesser. Same dag patta, my lord. 1 biga, 1 kata, 5 lesser has been taken away. So remaining land, my lord, 3 biga, 1 kata, 2 lesser became unfit for any use due to this acquisition. So that is to be considered. That is to be considered by the court below, my lord. That is not at all considered. My lord, regarding other portion, my lord, Zirat, etc., that has been taken intact and nothing has been said regarding my damage of other portion of land. Fourthly, the damage, if any, sustained by the person interested at the time of collectors taking possession of the land by reason of acquisition, injuriously affecting the other property, movable or immovable, in any other manner, or his earnings. So, my lord, here what happened? Some portion of my dwelling house has been demolished, and other portion remain, no doubt. But thing is this, my lord, when some portion of the house is destroyed, it is long time I am living there, my lord. I am a aged person. My house has been taken, some portion has been demolished. So entire house is affected, my lord. Ultimately, I am to leave that place. And that is submerged due to rainwater, my lord. Because the height of the railway is about 3 meters. That is my, in my application, my lord, I have made detailed statement before the learned court below, my lord. And your lordship would be pleased to see the evidence. In the evidence also,
No,
my lord.
your plea is that the severed land which now remains with you,
Unfair.
that is 3 bighas, 1 kata, 2 lechar
Yes, my
land,
lord. 3 bighas,
which remains with you,
1
you-
kata, 2 lesser, my lord.
2 lechars.
My lord.
That is not fit for constructing dwelling houses.
For the dwelling houses.
That is the only.
In other purpose also, my lord, rainwater accumulated there. Because when railway line is constructed, my lord, both sides is flooded like anything, my lord, during rainy season. It's a problem. And it in between the land, my lord, if a 3 meters high land is filled up, my lord, ultimately other side will be affected seriously. And that is my case, my lord. And I
No,
have elaborately
your
said-
pleaded case is that due to, even if you agree that during rainy season it becomes submerged, your pleaded case is that it is unsuitable for constructing any dwelling houses. You have not mentioned that it cannot be used for any other purpose.
But other purpose means, my lord, when it is inundated, my lord, ultimately it will be unfit, unusable. That word I have used, my lord, unusable.
How to assess the loss?
My lord, that is why, my lord, in the earlier point of submission, my lord, I submitted before your lordship. I am not claiming that per biga I am to compensate
No,
by.
what you are
6 lakh.
claiming? Now
My
what,
lord,
on what,
my
there
claim-
has to be some basis.
My lord, my claim was 2 lakhs rupees.
On what basis? On what basis?
My lord, it is before your lordship, it is before the court below, my lord, that land, same land. Out of same land, my lord, 6 lakhs per bigha has been compensated. 6 lakh per bigha acquired land has been given. So, my lord, in that case, my lord, some assessment is to be made. It will be in the reasonable.
You still remain owner of that plot of land. You can sell it to private persons.
Well, who will take it? My lord, when the land is not fit for a cultivation, not fit for dwelling houses, who will take it? So, my lord, I claim for some compensation.
You have
on
not
the
mentioned.
land, whether your lordship, my land 3 bigha, 1 katha, 2 lakhs of land, for other portion 6 lakhs per bigha has been given, and it become unusable. In that case, my lord, at least if it is considered that 50%, 3 lakhs per bigha, then also, my lord, I am entitled to some amount. 50% of the acquired land. Even 50% I have not claimed, my lord. I claim that at least 2 lakhs of rupees may be given. If your lordship taken that 25%, 25% of the compensation of 6 lakhs per bigha, my lord, then also it will be more than 2 lakhs, my lord. But the learned court below, my lord, consider nothing. Nothing has been said on my petition.
Anything else?
And this, my lord, your lordship would be pleased to see that page, that deputy commissioner structure 2,57,000, and regarding Zirat, my lord, it is a very less amount, my lord, that is 58,549 only given. I have detailed that so many trees are there, that valuable trees. That is not properly compensated, and that is why, my lord, I have objection and filed this petition. Learned court below did not consider at all. And your lordship would be pleased to see my evidence. PW1, my lord.
Yes.
I am not reading the whole thing, my lord. Already I have stated before your lordship. Your lordship just see my examination in page 7, para 11, my lord. Just para 11, your lordship may please to allow me to read.
Yes.
Para 11 and 12.
Yes, page number.
My lord, PW1, my lord, examination in page 7. PW1.
In the memo of appeal, it is there.
Not there, my lord. It is
In the original
on the
record.
lower court record, my lord.
Some Putul.
Court record.
Yes, what you want to show?
My lord, here I want to show that I am to state further that valuation of trees and zirat which stands upon my acquired land were not properly assessed. I beg to state that valuation of the trees and zirat which stood on the said acquired land would not be less than 2 lakhs. The price and value of the trees as estimated by the collector are totally inadequate.
No, but you have not given the numbers of trees, how much its value.
My lord,
How much?
I am coming. That since the same were assessed on the basis of schedule of rate of 2005, it is a case of 2011. As the price and value of the trees estimated by learned character are totally inadequate, since the same were assessed on the basis of schedule of rate of for the year 2005. That my land is taken in after 6 years. and prior to that, and as such the estimates so made by the learned collector requires intervention by the Honorable Reference Court to enhance the same to the actual quantum. I am to state that I have submitted RTI application to the District Agriculture Officer, Bongaigaon, on 4/12/2014, seeking information about god rate of Zirat. Entered the SDAO info and Public Information Officer, Office of the District Agricultural Officer, Bongaigaon, via his reply dated 23/12/14, inform me about Zirat value of different crops trees basing upon the third schedule of the rate available to them for the year 2005. So that has been calculated on the basis of 2005 rate, where the land has been taken in 2011 after 6 years, and my land was acquired during 2011. So naturally, the Zirat value trees, crops, and increases substantially during the period of acquisition of my land. That is the petition. That is my evidence. That is my petition. But the learned court below, my lord, did not touch anything. Just only said the value of the land will increase from such and such to 6 lakhs per bigger. So, my lord, it is a genuine grievance before the court below, my lord. It is to be said something, na, deputy that district court. Learned court below, so say something. Some reason is to be given that no, it is not be considered. It is, I rejected your plea on the so and ground. No ground has been given. Even nothing has been said on this.
It was not
point.
considered.
My lord.
It was not considered.
My lord.
It was not considered by the.
No, my lord, that is not said. In the judgment, my lord, if your lordship not considered, there should be a finding. If the judge remains silent, my lord, then it will be said that it's sidetracked. I have given evidence. I have stated in my petition. It is the duty of the court below, my lord, to say something, that to do justice, that see your grievance, this grievance is rejected. All right, then some answer has been given, but that is not given at all. So that is why, my lord, that judgment is not justified one. Let's say it has did not do the justice to me, my lord. And next your lordship will see.
As regards the compensation awarded against the Zirat.
My lord.
Zirat.
Yes, my lord.
Okay.
And now your lordship will see. Para 12. Similarly, I have also filed RTI application on 15/12/2014 to Divisional Forest Officer. I am reading page 8, my lord. Para 12. Seeking information about valuation of standing trees. Entered the State Public Information Officer, Assistant Conservator of Forest, Office of the AI Valley Division, Bongaigaon, via his reply dated 17/1/15, informed me about the detailed government value rates of different standing trees on the basis of the schedule rate for the year 2009, whereas my land was acquired in the year 2011, but the learned counsel did not consider the enhanced rate of the standing trees during the assessment process. So, Lord, 2009 rate was available, but it was taken in 2011 after 2 years.
What was the rate at that point of time?
My lord, 2009.
No, and in the year 2011.
2011, my lord, when we asked for RTI, because we cannot give the rate. Your lordship will consider, we cannot give the rate. The rate will be given by the concerned department. They said that the available rate available of 2009 is available. And another thing is that regarding Zirat, my lord, another reply has been given that it is only 2005 rate is available. So ultimately, my lord, when this is in evidence, when this is in the petition, my lord, my humble submission before your lordship, that honorable district judge, what to have considered this point. But nothing has been said in the judgment, my lord. Nothing has been said. So, my lord, I am deprived of the real value of Jirat and the trees, etc., over the land. So, my lord, that is why, my lord, regarding, my lord, valuation of my acquired land, my lord, I have no grievance, my lord. So, all right, it is 600 biga, 6 lakh per biga has come, my lord. But regarding this, my lord, submerging of my 3 biga, 1 kata, 2 lessa of land, my lord, I am entitled to some compensation as per section 23, my lord. That is to be considered. And another thing is that, my lord, regarding rate of Jirat, my lord, it is not touched by the learned court below. And I am entitled to some increase in the amount, my lord. Regarding rate of interest also, my lord, I have gone through the rate of interest, my lord, in the scheduled bank or the relevant time, my lord. So I am not hesitating regarding rate of interest also.
Yes.
That is my humble submission.
Government side, no, not today. We'll continue day after tomorrow as part heard matter because today time is over. As first hearing item, day after tomorrow. Heard, Mr. This is item number M.A. Sheikh Lanin, counsel for the appellant.
My lord, it may be on 17, my lord, because on 16 I have some trouble, my lord.
17 is
Friday, my lord.
Friday, we may not get time.
My lord.
It should be a
Otherwise, next week, my lord.
Tuesday.
Tuesday, my lord. Tuesday will be 21, my lord.
Okay.
My lord.
And Mr. M.A. Sheikh, learned counsel for this appellant. Also heard Miss D.D. Burman, learned additional senior government counsel, appearing for respondent number 1, as well as Mr. K. Gogoi, the learned central government counsel, appearing for respondent number 2. The hearing remained inconclusive. Hence, let this matter be listed again as part heard matter on Tuesday is 21/7 as first hearing item. List accordingly.
Much obligation.
My pleasure. Item number 32. May kindly be fixed the next week, 23rd, if possible, my lord.
If not possible, then
Then, my lord, any other day, my lord, on 30.
because it is not possible.
On 30, by 30.
Hearing matter.
Hearing matter.
And this matrimonial matter.
Matrimonial matter regarding maintenance.
Item number 32, Kityapari. Tell them.
Fixed up. Well, if possible, my lord, in the month of August.
August. No.
August.
6th.
6th of August.
6th of August. Item number 32. Due to paucity of time, this matter could not be taken up. Please, this matter on 6th of August. Yes.
May I please, your lordship? Lordship, item number 19, lordship. Succession appeal, lordship.
It is not reaching for many days.
Yes, lordship. That matter, lordship. My senior is coming from Calcutta, lordship.
How to accommodate?
Lordship, may kindly fix it on 25th, lordship. 25th of August.
Who is for the other side?
For the other side.
25th August.
It is connected with some other case pending before some tribunal.
Yes, lordship. NCLT. Yes, pending.
Heard Mr.
A. Borwal.
A. Borwal, learned counsel for the appellant. Also heard Mr. B.D. Dekar, learned counsel for the respondent number 1 and 2. This matter could not be taken up for hearing due to paucity of time. Let this matter be listed on 25th of August
At 2 PM, Lordship.
at 2 p.m.
Fix matter.
Let us see.
Master.
Great, my lord, in respect to item number 23 and 33, can it be taken up on August, my lord? 23 and 33.
23 means date has been given. (33) MFA. 30 MFA, the court master will see whether.
Any date, my lord, as per the convenience. Much obliged.
My lord,
Yes.
similar prayer in regard to item number 20, for the appellant, my lord. Actually, we have applied for some relevant documents through RTI, which has not yet come. So, Lordship, I pray for if the matter gets posted on some later date in the month of August, Lordship. A big date.
If you want it, we can give it in the month of October.
No, Lordship, August will August later part.
August may be difficult. September, you take a date from court master.
September 1st part, Lordship. A fixed date is required. Just
Okay, give
that
a
is
fixed
the prayer. Deeply obliged.